relevant paragraph, my lord, the paragraph they have mentioned that one, your lordship may kindly see.
Yes.
बस एसोसिएशन के प्रतिनिधि द्वारा सूचित किया गया है कि समझौता प्रारूप का एमबी एक्ट 1988 के धारा 885 के तहत प्रमुख समाचार पत्रों में प्रकाशन नहीं हुआ है। देयर आफ्टर माय लॉर्ड
सूचित किया जाता है नेक्स्ट
अभी अरुण कुमार गुप्ता एवं अनेक प्रतिनिधि सूचित किए। दिस इज वेरी फंडामेंटल।
It is a preliminary notification. So pursuant to notification, the association has filed objection and they have been heard. So final publication has not been made.
Are you going to take care of all these things in the final notification?
Yes.
If you are taking care, it's all right.
Yes, madam. Yes,
No, no,
everything
that
is all-
much, madam. That
Soon after the final publication is made, then the petitioner know that whatever submission made, whatever objection made, whether that has been considered or
You are trying to say that it is a premature thing.
yes,
Let him wait till the final.
yes.
no, madam, to that.
So why? Anyway, now why don't you clarify?
Yes, madam.
You clarify it. I'll put it next week or clarify if you are taking care of his objections because Jharkhand has taken care of it.
No, Jharkhand has kept it abeyance,
So
madam.
why to invite litigation?
Not, it is the requirement under the law
Hmm.
that the proposal shall be published in both the states.
Yes.
This notification made in our state. So similar proposal has been published in the state of Jharkhand and their objection has been raised and this order has been.
This is a final order according
Yes,
to you. Jharkhand is a
Yes.
final order.
Thereafter, no final publication has been
That's
made.
what you just seek instruction.
Fine.
Whether the objection raised by him, are you going to take care of that? Otherwise, you are unnecessarily inviting litigation.
It was not reciprocal.
That has been
Reciprocating.
considered. Milord. They-
Consider and reject it.
So,
What do you say? That's the question.
that, here,
Have you
Milord,
rejected it or
No, no, no.
really
Milord,
taking
here
care of that?
No order can be passed on. Milord,
I'm
here-
not going to pass any order. I'm just holding it for next
No,
week.
no, no,
you
Milord,
seek instruction.
here, Milord, the requirement is the proposal for entering into any agreement between the states. The proposal shall be published in the newspaper. That is one. And anybody agreed by that proposal or any objection or suggestion, they may file before the authority. And after considering that, the final publication will be made. So, Milord, they have filed objection and they have been noticed for hearing.
I
But
understood it.
final publication has not been made.
Therefore, I'm just holding it for a week or so. You tell me when the final publication is likely to be done, and whether in the final publication, whether their objections are taken care of or not.
And these
Otherwise,
issues,
you are inviting further litigation.
Yes.
Therefore, I'm saying.
yes, madam.
I'm not passing any order, simply into holding it.
Fine.
Holding it, lease it on 18th. You get the instruction.
And let my friend also take instruction with regard to the Jharkhand authorities, but they must have communicated.
That's part of the record.
Yes, madam. They must have communicated to the Odisha authorities that, they have kept it
Madam,
intact.
The states, tenants also to the instruction.
Annexure
Regarding Annexure 5 as well. Annexure 5 as well.
So what is the view of the Odisha?
Similar, such a repetition should not be entertained.
I know, I
Because suppose
understand,
in
but
case-
I'll tell you, you are right, absolutely right.
Fine.
I'm with you. But if I'll dispose it up, again you are inviting another writ petition. Better that, why don't you set it? And many
suppose in
writ petitions
case
will
you are
follow
not-
thereafter. Better you do it.
Yes,
When you came to know
Fine.
that there is a problem, why don't you solve it?
And with that assurance, the case can also be
Yes.
disposed of, my lord.
If you assure, then I'll dispose it up.
Madam,
So
What
that
is
is the reason on 18th you come and tell us that we are considering favorably, then it's all right.
Yes,
We'll dispose it up.
madam.
Yes.
okay.
Next. Item 2.
On behalf of Mr. Jain, I am permitted to place this matter, my lord.
Yes.
Here, my lord, alleged offences under section 103, my lord, 302 of old act, my lord.
There is a,
Uh,
yes.
My lord, the petitioner has not been named in the FIR since he is closely related with the accused persons. He is pending arrest, my lord, and filed this application.
That's right, but same, 302 case.
My lord, there is no allegation. That's why I'm not
Allegation,
saying he has been
still-
called for
still-
allegation of, yes.
Still it in investigation stage. What are the materials you have collected?
Let's on statement of the Lakshman Chandra Rao.
Yes.
I would like. They
Reading.
said that
Jayant Kumar Barik
yes,
against
ଡାକ୍ତରଖାନାରେ ପହଞ୍ଚିବା ସେ ଲୋକ ତାର ନାଁ ସଞ୍ଜୟ ରାଉତ କହିଥିଲା ଓ ତା ସାଙ୍ଗରେ ଥିବା ମଦନ ପାତ୍ର, ତା ସ୍ତ୍ରୀ ମଧୁସ୍ମିତା ପାତ୍ର, ରମାକାନ୍ତ ବେହେରା ଓ ରମାକାନ୍ତ ଭାଇ ପ୍ରଶାନ୍ତ ବେହେରା, ଜୟନ୍ତ ବାରିକ ଓ ପପୁ ବେହେରା ମିଶି କୋଦାଳ ବେଣ୍ଟରେ ପିଟି ପିଟି ତାର ଗୋଡ ଭାଙ୍ଗି ଦେଇ ମୁଣ୍ଡରେ ଗଭୀର ଆଘାତ।
No, no, my lord.
no will not help.
No, no, no,
There,
no, my lord.
there are evidences.
Matter arising out of illicit
Whatever. But his name is there. You have assaulted.
If pity, that is the statement.
Ganesh Sahu also given his
Who all are the state witnesses?
Miller's
Name of the witness.
Miller's Lakshmana Chandra Raut and Ganesh Sahu.
Ganesh Sahu.
Lord, I pray, my lord, let it be urgent. I will,
No adjournment.
my lord, I'm since
302
on,
case,
my lord,
two witnesses have said
no, but I'm submitting on behalf of Mr. Jena. That's why, my lord, that's why I'm, my lord.
either I'll have to write a judgment of the order or you have to.
No, on behalf of Mr. Jena, I am submitting. That's why he is in.
Maybe I'll pass it over if you say. I'll pass it over.
He will not, my
These are
lord.
unnecessary pending.
His mother died, my lord. That's why.
Whatever, I'll pass it. There is nothing. Even if he comes, the same fate. 302
Still,
two
my lord.
witnesses are saying that you have assaulted as a result of which somebody
Still, my lord,
with anticipatory bail.
still, my lord,
Asking
my
more.
fear is that, my lord, since I am submitting on behalf of Mr. Oyo and he is
Absolutely right, but
my lord,
asking more. Let it be tomorrow. Let it be.
Let him sorry.
That is his option, whether he surrender or not. Sir, shall I pass that order that you will surrender? I will give some time. Surrender and seek regular bail. You will get regular bail, of course.
my lord, day after tomorrow, my lord, Mr. Jena will come
Tomorrow.
and he will do.
Tomorrow. Yes, tomorrow. Yes, next.
Very.
Item 3.
Allegation 139.
Yes. It is there?
Yes, madam.
Yes. Yes, sir.
My lord, the matter day after tomorrow.
Tomorrow.
Day after tomorrow. His mother died and
Okay. Day after. Okay. There.
That's me.
What are the injuries? Head injury.
Yes, head injury.
Assault by means of lathi bamboo lathi.
Hmm?
Assault by means of bamboo lathi and then
Assault by means of
lathi bamboo lathi.
huh?
Bouncer bade.
Blunt
Yes.
object.
First offender no artist.
also more.
Refer to he was admitted to hospital for surgery. You surrender the same day.
The statement is there.
Surrender same day.
Tarikh list
Right.
first of second of same.
On 2/5/2026, CD was called for peruse the CD in view of the injury sustained by what is his name? Niluda. Injured. Although I'm not inclined to anticipate to be over if the surrenders same day. Same day.
First of second.
That's all. Yes.
Tarikh list in the meantime one of the court.
Parity is there. Anybody is granted bail? Who?
The father of the petitioner.
Huh?
The allegation against the
11
father and the
the
son.
petitioner submits that the father of the subsequent petitioner has already been admitted to regular bail. Therefore, the petitioner is entitled to parity, the parity ground. Yes.
Item 4.
The report has called for.
Yes. Yes, sir. CD.
Yes.
What are the allegations?
Assault by means of died on the road.
Injured statement is there.
Same problem. Head injury.
Skull and
Simple was simple.
Head is simple. Head injury and
Well, the first offender having no antecedents.
same
day, Lord.
same order. Does it? Yeah. I record the word. Bhojraj. Huh? Injured Bhojraj. Yes. Same day. Parity is there?
No, man, it's a single accused, sole accused.
Same. Yes.
Item 5.
109 along with the other offences. Last occasion we have to fulfill the CD in the injury report.
Sorry? CD is there?
Heading.
Problem. Same head injury.
Yes.
There is no allegation.
Multiple
against the
injury.
petitioner. Specific allegation against one Bhimasen Rao. Bhimasen Rao along with 10 others.
What is your name? Your name is?
There is no allegation against the present.
There is
petitioner.
Cooler out. Just see cooler out.
Bhimasan assaulted, but this person is along with that Bhimasan.
Along with is something. Who assaulted? Who assaulted?
Bhimasan.
Bhimsen. Right. On 2/5/2026, CD was called. CD was produced. Perusal up to the injury report reveals that Lakshmidhar Vishwa has received multiple abrasions and the forehead and all the injuries are simple. Perusal of the FIR and other material collected by the police so far also reveals that who has given Benudhar.
Bhimasan has assaulted.
Reveals that Bhimsen has assaulted the assaulted Lakshmidhar. Bhimsen has assaulted Lakshmidhar. As a result of which the injuries so caused, and the petitioner had accompanied the principal accused Benudhar regarding the yes. Granted. Yes, next.
Item 6.
The allegation of
CD has I received CD, but the injury report has not been received because
Day after.
IO Millers has stated that the concerned doctor will study Lee Millers, so he will not procure the injury report.
Day after tomorrow you get it.
Millers he will study him.
Then it will never come. Then he will be.
Let him surrender subject to Millers.
What are the? Let us see the allegations.
Yes,
Let us see the allegations. What is the name of this?
They have admitted in hospital.
Amresh Behra, Manoj Kumar Behra, Krishna Behra. Yes. See,
Manoj
and
Kumar Behra,
what about the other material? Do you have the other material?
There is a statement of Millers, complainant Millers.
Read it.
Millers. ମୋର ନାମ ଶିବରାମ ବେହେରା ଅଟେ ତା 2/1/2026 ଆପଣ ନିକଟରେ ଦେବା ମୋର ବୟାନ ଏଇକି ଯେ ଗତକାଲି 1/1/2026 ଦିନ ସନ୍ଧ୍ୟା ପ୍ରାୟ 7 ଘଟିକା ସମୟରେ ମୁଁ ଓ ମୋର ଭଉଣୀ ତୁଳସୀ ବେହେରା, ମା ଗୁରୁବାରୀ ବେହେରା, ଭାଇ ସନ୍ତୋଷ ବେହେରା ଆମ ସମସ୍ତେ ଘରେ ଥିବା ସମୟରେ ଆମ ଗ୍ରାମର ଅମରନାଥ ବେହେରା ପିତା ଉପେନ୍ଦ୍ର ବେହେରା, ମନୋଜ ବେହେରା ପିତା କହ୍ନେଇ ବେହେରା, କୃଷ୍ଣଚନ୍ଦ୍ର ବେହେରା ପିତା କହ୍ନେଇ ବେହେରା ସମସ୍ତେ ଆସି ଆମ ଘର କବାଟରେ ତାଲା ପକେଇଦେଲେ। ଆମେ ସେମାନଙ୍କୁ ତାଲା ଖୋଲିବା ପାଇଁ ଯେତେ କହିଲେ ବି ସେମାନେ ଖୋଲିଲେ ନାହିଁ। ଏହାପରେ ମୁଁ ଆମ ଘର ଛାତ ଉପରକୁ ଚଢ଼ି ପଡ଼ିଶା ଘର ଦେଇ ଆମ ଘରର ତାଲା ଖୋଲିବା ସମୟରେ ଅମରନାଥ ବେହେରା ଆସି ଖରାପ ଭାଷାରେ ଗାଳିଗୁଲଜ କଲା ଓ ମୁଁ ତାକୁ କାହିଁକି ଆମ ଘର ତାଲା ପକେଇଲୁ କହିବାରୁ ସେ ମୋ କେତେ ଅଭଦ୍ର ଭାଷାରେ ଗାଳି କଲା। ମୋ ଭଉଣୀ ଓ ମାଆକୁ ମଧ୍ୟ ସେମାନେ ଗାଳି କଲା। ଏହାପରେ ଅମରନାଥ ବେହେରା ସାଙ୍ଗରେ ଆଣିଥିବା ଏକ କାତିରେ ମୋତେ ଜୀବନରେ ମାରିଦେବା ପାଇଁ ମୋର ମୁଣ୍ଡକୁ ଏକ ଚୋଟ ପକାଇଲା। ମନୋଜ କୁମାର ବେହେରା ଓ କୃଷ୍ଣଚନ୍ଦ୍ର ଆସି କାତିରେ ମୋ ମୁଣ୍ଡକୁ ଓ ବାମ ହାତକୁ ଚୋଟ ପକାଇ ହାଣି ଦେଲେ।
Specific allegation against you.
The injured persons are the informant in the present case. Here they have admitted to hospital as a outdoor patient. They are not.
All these things are irrelevant. You have given blow.
No,
That is the allegation.
this is the
Amarnath has
statement.
given blow, and Manoj and Krishna joined them.
How many injured he is sustained? That is not that the injury report
Subject
is
to
not able.
verification of the injury.
Subject to verification.
Verification same. Subject to verification of injury. Same day. Okay. Allegations against okay.
Item 7.
Six allegation.
Yes, sir.
I am for the informant, my lord.
If you notice opposite party,
I am for the informant.
Dondor and constituted appearance.
Directed to status of investigation.
Sorry?
Charge sheet has been filed Millers on 18/4/26, but investigation is open still.
No, not been
Preliminary
arrested.
charge sheet has been filed.
Not arrested till yet.
Investigation is open.
Then that's good that you have.
Without arrest, not arrested.
Then
Without
why
arresting,
why
you
close?
Arresting means you are
Anyway.
absent.
We'll see.
I am the informant.
Preliminary charge sheet has been filed,
Yes, my lord.
and the further charge sheet, supplementary
Yes,
charge sheet will be filed.
Section
What are the allegations against it?
Allegation, my lord.
Your Honor,
Read the
My lord,
info.
there is a two statement of victim.
one six was recorded.
One has been stated that I am in my own consent I have gone to the with the accused person, but thereafter subsequently it was changed by the victim that I was in not good state of mind. Thereafter he has given statement that ମୁଁ ଅଭିଯୋଗକାରୀ ପୀଡ଼ିତା ରୀତା ମହାକୁଡୁ 26 ବର୍ଷ ସ୍ୱାମୀ ସଞ୍ଜୟ ମହାକୁଡୁ ଗ୍ରାମତା ପୋଷ୍ଟ ସକାଂଶ କେନ୍ଦୁଝର ଆଜି ତା 2/2/2026 ଆପଣଙ୍କଠାରେ ମୌଖିକ ବୟାନ ଏଇକି ଯେ 18/2/2024 ମୁଁ ସୁସ୍ଥ ମସ୍ତିଷ୍କ ନଥିଲି ଓ ମୋର ମସ୍ତିଷ୍କ ସ୍ଥିର ନଥିବାରୁ ଆଜି ମୁଁ ତା 20/2/2026 ସୁସ୍ଥ ମସ୍ତିଷ୍କ କୌଣସି ଚାପର ଗ୍ରସ୍ତ ନ ହୋଇ ମୋର ବୟାନ ଦେଉଅଛି ଯେ ଦିଲ୍ଲୀ ଘଣା ଏକ୍ୟୁଜ୍ ପର୍ସନ ମୋର ସମ୍ପର୍କରେ ମୋ ମାମୁଁ ପୁଅ ଦିଅର ହେବ। ଗତ 23/7/2025 ଦିଲ୍ଲୀପ ଘଣାର ଭଉଣୀ ସୁମିତ୍ରା ମହାକୁଡୁ ତାର ଭାଇ ଦିଲ୍ଲୀପ ଘଣା ଓ ସହିତ ଭୁବନେଶ୍ୱର ଯିବାକୁ କହିଲା କଲି କିନ୍ତୁ ଦିଲ୍ଲୀପ ଘଣା ମୋତେ
When the first statement was made?
ଷ୍ଟେଟମେଣ୍ଟ ମିଲର୍ସ ମୁଁ ଅଭିଯୋଗକାରୀ ପୀଡ଼ିତା 26 ବର୍ଷ ସଦନ ସହ
Date.
18/2/2026
18 to. Okay. And next statement?
Next statement is Miller's that is 22.
After 2 days, she changes her
Yes,
version.
yes. And 164 statement is there.
164
Stated repeated the second statement.
second statement.
Yes.
164 recorded on.
Recorded on Miller's 22.
22.
Yes.
Preliminary charge sheet filed on.
Let's just say Miller's 18/4.
18. 26. You shown him as a absconder.
Yes.
Just see.
That it has not copy not survived, but I spoke to IO that's today here.
Give the two.
My introduction.
She 26-year-old.
Yes.
Give first statement. She gives
Yes.
saying that nothing has happened.
Nothing.
Thereafter, she changes her statement.
After
And you
2 days-
file it.
After 2 days and 164 will be there. That is the 164.
The accused is moving and threatening
What is the
the
name? Dilip Rana.
Dilip Ghana.
Rana.
accused is moving and threatening the husband of the petitioner to compromise the case or to face direct consequences, my lord.
I flag mark the two statement of the victim.
During investigation, the statement of the victim was initially recorded under section 183. Under section 161. Where is the first statement?
First let's have flag.
First statement is
Two flag is there. First flag is first.
18. Sukanti.
Yes.
Sukanti. Under 180 of BNSS on 18/2/2026. And in the sixth statement, the victim is not implicated in present petition and no specific allegation was made against him. However, subsequently on 20/28/2026, the petitioner, the victim girl has changed her version and making specific allegation against the petitioner. And subsequent thereto on 22/2/2026, statement of the said witness was recorded by the recorded under section 183 BNSS. In the said statement also, she reiterated that second statement given to the police on 20/28/2026. After investigation, charge sheet, preliminary charge sheet has already been filed on 18/4/2026. Our main counsel for the state submits that the preliminary charge sheet is submitted, showing the petitioner original. although since the victim was changed their version, initial version, and implicated it, although we can try to grant up to the relief sort of. However, since the petitioner has been absconding, as a result of which the final charge sheet could not be filed. Therefore, it is open for the petitioner to surrender on the same day, date of the petition. I have written everything. You will get the bill now. Yes.
Informant, my name is Gagan.
Informant by KP Ridra लिख दियो. Notice was issued to informant Mr. Nando. Mr. Nando है KP. Somnath Nando. ठीक. Taragu लिख लो on 23/4/2026 notice was issued to Nando has entered opinions. Yes.
Item 8.
Item 8, my lord, I pray on the paper tomorrow, the matter is going to settle between the victim,
Sorry?
between the petitioner and the victim. Matter, the victim has come today. I will prepare a affidavit so that file before your lord.
76.
Victim से बाहर 4 मास थिला तांग घरे after 4
What
months,
is the age of the victim?
my lord, age of the victim.
It was for 17 years
Set up.
at the time of.
They have married.
Is a POXO case, how can she?
नहीं 17 पर से बाहर के तांग घरे 4 मास थिला
file
ताके
a-
dispute हो गला.
See, you file a quashing petition and impress upon that court.
My lord,
POXO case, how can I, or
after
relying
law-
upon the affidavit of the victim girl, how can you?
as because they are going to settle the issue and going to marry each other. कारण से रहितला सेटा देके documentary proof किछ नथि.
What is the age of the girl now?
Now, my lord, more than 26 above.
When
एटा
paper
बहुत
was
पुराना
written?
affair.
2019.
2019 affair.
You have been absconding, huh?
After no, High Court of
Twice your bail application rejected.
काली आसु नले after lunch आसु. So that.
Okay, after lunch. Let us save the life of these two people. Somehow, something
काली टिके हेले भलो
will work out. Something will try to work out.
My lord.
I will see.
काली टिके हेतले better हेतन.
Okay, tomorrow.
Kal-
And the affidavit has to be drafted in such a manner, then it should impress the court.
Well,
Not that don't try to play, with words. It should be very specific,
Specific.
and because the girl's life is involved.
well,
So therefore, who will give the affidavit?
so that the petitioner will not harass in future to her.
After obtaining the bail, then he will reject her and she will be in trouble.
My lord.
So all these things has to be. No, you do one thing. You file the affidavit and give a copy. Today you file the affidavit, give a copy to him. He will verify it day after tomorrow. I'll take.
There.
Today. Today you give it. Verify it and verify from the IO. Let him go and verify from the house whether the family members have accepted or not. Otherwise, he will be again, troubled. Today by afternoon you give it.
Will member टिके accept करना तो भी dispute.
Whatever you give it to the IO, let the IO go to your house and verify. The safety of this girl is very important, Yes.
9.
Lordship has called for CD and C. Can I pray for day after tomorrow?
CD hasn't come. What happened?
So I've spoken to them in the morning only. They're sending it today. Can I pray for day after?
Despite two opportunities, CD has not yet been received by the State Council and C seeks one more opportunity. He is the matter day after. Yes.
Item 10.
Firstly, on the last occasion, CD has been called for.
Yes, CD is there.
These are always
So I've just now got the CD. Can I pray for tomorrow? Just now got the CD.
What are the offenses?
411
It's a cyber fraud.
Cyber fraud. Lordship.
Driver, okay, tomorrow, yes.
Item 11.
109, injury is simple. Because the person, the co-accused, who is my brother.
Injury report is there?
Lord, injury is simple. The person who was assaulted, he has been granted bail. Lordship, may kindly say,
Who is assaulted?
Lord, my brother, Nilanjan. Lord, second page, last part. Second page, last part.
Where is the affair? The statement of witness from through. The component available on the comparison of the injury report reveals that the injured had sustained incident. Counter cases. And where is that you, Nilachal has assaulted?
Page 12.
Huh?
Statement I have
Page 12 one.
Page 12.
Yes. Page
statement I
12.
have
Page 12 of the
page 12
bill application.
Okay.
bail application I have annexed one.
Nilachal has done it.
Yes.
Yes.
He has got the bail, but he was not well, therefore court has
The
given it.
regular,
Anyway,
let him surrender.
no, main accused has got the bail. Well, it is not the case in shown to allegation of the on such and such days on 1/5/2026, CD was called for, and the responsible for the state has produced the CD, where from it is the injury report reveals that Prashant Das, the injured, has sustained two injuries, but both injuries are simple in nature. The learned counsel for the petitioner has drawn the attention of this court to the allegation made in the FIR. It reveals that the brother of the present petitioner, United South, has in fact assaulted Prashant Das, the injured. Injured, and the present petitioner had accompanied his brother, United South. The trial court, by order dated 6/4/2026, has admitted the co-accused Nilachal Sahu on bail, while allowing the bail application 91 of 2026, inter alia observing it under last paragraph. In view of the information given. Yes. Yes. Yes.
Item 12.
Well, last time, for injury report, my lord.
Yes.
Case on a counter case, my lord. The same day.
Assault on head by sword.
Sorry?
Assault on head by sword. Injury is grievous. Hospital reason re.
Grievous.
First or second.
CD is called for by the order dated 1/5/20. The injury report of Srikanth Patra reveals that he has sustained a severe lacerated injury. That grievous injury. Review of that. Surrender. Yes.
Item 13.
Yes, madam.
Of the petitioner, my lord, petitioner and his other employers filed an affidavit.
Where is that affidavit?
The cause is reflected that
Yes.
it's a flag C.
Sorry?
It
Yes,
was
I got
flag
it.
C, but not flag C.
How many cases are there?
They don't have any criminal antecedent.
No criminal antecedent in the first matter.
They don't have, any of them doesn't have any criminal. antecedent.
What are the allegations?
गाड़ी छोड़े कि नहीं जाइथिले snatched away the vehicle गाड़ी गुलज करिकि ताको रखिदेले बिक्री करिया पे and that vehicle has been recovered.
Recovery.
Vehicle.
Release of the petitions are found by order dated 1/5/2026. The petitioners were directed to file a comprehensive affidavit disclosing the allegations. Persons there they filed the affidavit disclosing that none of them have criminal cases. None of them been and for the state for the subject that the vehicle which was stolen by allegedly stolen by the petitioners have already been recovered in view of the convention granted. Yes. Yes.
All five.
All five are
All-
co-accused.
Okay, sir.
Yes.
एकाडी काम करछन गाड़ी नहीं जाउ
Huh?
एकाडी काम करछन गाड़ी नहीं जाउ
They started their career now. Yes.
Recovery agency.
You have started your career. Yes.
Item 14.
My lord, this is the petitioner is a daily wage laborer. He is
Have you filed the
in
affidavit?
miserable condition.
Have you-
Affidavit has been filed.
Have you filed the affidavit? No criminal antecedent. Yes, madam.
No criminal. Receiver of stolen property. Any condition.
It is recovered.
He is absconded.
Absconding.
He is absconding. So
Absconding, then you have to surrender.
Lord,
You don't cooperate, why should you be protected?
Charge sheet has
Surrender-
been filed showing them absconding and NPW has already.
Charge sheet filed on? It is in the equivalent form for investigation expedition also pursuant to the order dated 1/5/2020 and comprehensive affidavit has been filed on 8/5/2023. The declared in that the petition was existent. After investigation, charge
14 to 26.
14?
14 to 26.
14 to 26. After investigation, the charge sheet has been filed in the present case on 14 to 2026, showing the petition was under. In view of the aforementioned, the petition is not entitled to grant appointment to bail. However, it is open for the petition to surrender same day. Yes. Yes.
Item 15.
On the last occasion, Lordship, CD was called for simple injury, Lordship, allegation of assaulting by wooden plank.
What are the injuries?
Injuries are simple, but at the same time, head injury.
Head injury.
Head injury.
ଖାଲି ମୁଣ୍ଡ କ୍ଷତ ହେଇଛି, Lordship. Allegation FIR ରେ ଅଛି.
What about your antecedents?
No antecedent, Lordship. First time offender.
Head injury. Same day you surrender same day.
Lordship, injury is simple, Lordship. ଖାଲି ମୁଣ୍ଡରେ ବେଟ୍ ରେ
307 head
ବାଡେଇଛନ୍ତି.
injury, it's like surrender and go.
The injuries are
Simple.
very,
But at the same time, there are two injuries.
very
Both are on the
aberration
head.
kind of injuries.
Aberration.
Aberration kind of. Head, periphery. The injury report of Soros Brusti placed with the CD reveals that the injuries are simply in nature. However, this is not on the temporal reason, temporal reasons of the head. The police specifically submits that the petitioner has no criminal injury.
No.
Subject to the yes.
16.
In the last episode, Lordship directed issue notice to the informant. I already filed the postal liquidates on 8th month.
Yes, what is the position? Service.
PD has come. From the last email,
Notice to go to the
notice to the
informant.
opposite
No, no.
part number.
What is this offense?
Sir, allegation of IT fraud.
Service is complete.
No, notice to go, my lord. I have already filed the postal liquidation. That is not been accepted.
Service.
The noting is
Liquid not filed. Liquid not
already
filed.
filed.
On
Informant.
4/5/2026, notice was issued to the informant opposite party. Opposite party have been implicated.
Yes.
Opposite party number 2. However, since the requisites were filed so late, the notice could not be served. The requisite already filed. The utilized for proper service. This matter next to that. Yes.
Just wait.
Item 17.
My lord, also last occasion notice has gone.
Item number 70.
Yes.
Requires some more time to get the notice of it. One more.
What about the notice? Have you served?
Regarding the notice on
Notice only.
Yes.
By the order dated 21/4/2026, notice was issued for the informant of the victim to be served through the IU, but the service report was not been obtained. At least matter. Yes. Next,
Item 18.
I loaded fixed.
I'll give it.
My
Yes.
Item 18 also, I request some more time to serve the notice.
since 21 foot.
By the order dated 21/4/2026, notice was issued from source. Notice has not yet been served, and what last opportunity is granted. Yes.
Fix up a date for the
Last opportunity. Yes.
Item 19.
19 wheeler. There are 4 persons who are standing at a bus stand, Millard, and the 40 kg of ganja was Millard seized from a motorcycle which was standing nearby, Millard. I am for 2 fast bail application and he is for sub item. There are 4 persons, Millard. And so far as the antecedent we have already
Madhya
filed.
Pradesh.
Sorry?
Madhya Pradesh with the affidavit.
Madhya Pradesh.
ସେଥିପାଇଁ antecedent ମାଗିଥିଲେ ଆମେ 30 ତାରିଖ
Have you verified the affidavit?
Affidavit.
Verified.
already time given for verification.
In affidavit, they have to say that they're disclosing their residence and the local surety and everyone. They have only stated they don't have any previous.
What kind of affidavit you have filed? Just see. You are only disclosing your name, which we know, all of us.
I have no antecedent, my lord. I have made it.
But you are from outsider. I asked you to file the affidavit stating your permanent address and phone number, something.
Local surety.
How will you trace it up?
And local surety.
Local surety also. Nothing is there. At the persons to the order dated 21/4/2026.
Next
affidavit has been filed. However, the affidavit is not comprehensive in nature. Therefore, the petitioner seeks one more opportunity to file a comprehensive affidavit. Please the matter. File a affidavit. Okay. You want to disclose who will be your local surety and all, but thereafter it's very difficult to trace these people. That's the whole difficulty. Otherwise, you are entitled to bail.
Aadhaar card भी देइछि ता पक्षर.
You file it properly. Yes. Next.
Item 20,
My friend Jyoti Babu is appearing for the other.
Connected record, man.
Yes.
ନାଇଁ ଯୋଉ କନେକ୍ଟେଡ୍ ତଳଟାରେ
correct. Yes.
ସାର୍ କରୁଛନ୍ତି ଚାର୍ଜସିଟ୍ ସବମିଟେଡ୍
That is submitted.
Charge sheet submitted, both the petitioners before my lord, they are the BTech students. They are prosecuting their study. Unfortunately, out of greed or whatever may be, what they did, the allegation is that I told my friend's client to open an account, and through that account, some money was transacted. Money deposited and it was transferred. So that is the allegation. Financial gain, neither they received any financial gain. In that connection, they were in custody for considerable period.
No, whether you are a state player or national player or international player. In these kind of cases.
My
yes state play
You are a state player, then we can.
ନାଇଁ state player
International player.
ନାଇଁ ନାଇଁ ଇଣ୍ଟରନ୍ୟାସନାଲ ଆଜ୍ଞା
Engineering.
ସେ କହିଲା 10,000 ଟଙ୍କା ଦେବି ଗୋଟେ ଆକାଉଣ୍ଟ ଖୋଲ ଆକାଉଣ୍ଟ ଟେ ଖୋଲା ହେଲା
From the money came.
ସେଇଟା ଆଜ୍ଞା
That was not traced out during course of investigation.
investigation
Who sent the money? How it was?
I'm seeking one password.
Password.
One password.
You just tell me where from that money came.
Only problem is कि गोटे मासरे 72 lakhs ଆସିଛି.
ସେ ଆସିଲା ପଳେଇଲା ପଇସା
Money.
That is the Asila Padela, that is the whole difficulty.
ସେଇଟାକୁ ସେ କେବଳ
And this
Data
is, you are making it so simple, but it's not so simple.
No, no, no.
It is eroding the economy of this country. It is much more serious than the.
Most of
It
the
is
cases,
cutting off the pocket of all of us.
yes yes
most of the cases, the investigators are not tracing out the person.
Because I'll tell you why it is happening. The type of the modus operandi used by these people, it's the investigating officers are not able to find out.
Exactly.
That's what the other day I was saying. Even you don't know what is it, but you are arguing the case. Even I don't know.
yes
And the prosecutor also doesn't know.
that's it that is
This is what exactly the.
how
That was not traced out, no charge sheet has been submitted.
Let us see, madam, just see.
One
Tell-
password.
Password. Okay,
One.
password. Okay.
21,
You have custody since
custody 22/2/26 23 ଫେବୃଆରୀ
February.
22 ଫେବୃଆରୀ
22/2/26 same day.
Same. Yes.
21,
Can I do it for tomorrow? Better
Also,
tomorrow. Let it be tomorrow. Why you will start? Huh? Yes.
21, my lord, kindly pass over.
Password. Password. Okay. Yes.
22,
52 million below commercial quantity since I have one criminal antecedent of million. Last occasion I served a copy to my state council million.
Yes.
Verify the.
Have you verified, madam?
can I pray for
ଆଉ ଗୋଟେ
Very the affidavit.
some note?
ଏଟା ବି ଆମ ଏଫିଡେଭିଟ୍ ଆସିନି ଆଉ ଗୋଟେ ଡେଟ୍ ଗୋଟେ ତାଙ୍କୁ ଦେଇଥିଲା
Affidavit is not come. Pursuant to the order dated 2/5/2026. Mr. Ponda says.
ସେଟାରେ ଅର୍ଡରରେ କିଛି ନଥିଲା ଅର୍ଡରରେ ନଥିଲା ଆଫିଡେଭିଟ୍ ମୁଁ କିନ୍ତୁ ଦେଇଥିଲି ଫାଇଲ୍ କରି
Obtain instruction regarding the.
Antes.
Okay. And Mr. Pondal and counsel for the petitioner submits that he has already filed a comprehensive affidavit. However, the same is not there on record. And the AC is directed to locate the same and place it on record. The advance copy of the same has already been supplied to the state council, who shall verify the same and file a report in that regard. Please see my promises. Yes.
Next week. Within Miller vacation. Vacation.
Yes.
23.
Resolution. This is lesion theft of a gold chain minor. Allegation against one unknown person minor. What 6 persons have been
Organized crime.
apprehended?
Organized crime. On the last topic,
So-
Lordship has directed
Four antecedents.
Yes, ma'am. ଦୁଇଟା ଥିଲା ତାର ଗୋଟେ 22 ର ଗୋଟେ 23 ର ଏଇଟା ଆଟ୍ ଏ ଟାଇମ୍ ଗୋଟେ କେସ୍ ରେ ଆରେଷ୍ଟ କଲେ ଆଉ ଦିଟା ରିମାଣ୍ଡ କଲେ
Whatever, there are 4 antecedents.
yes madam
Petitioner number 2 has 2 antecedents.
yes madam
See,
Petition number 3 also two antecedents. Yes.
that affidavit may be served upon you.
Copy of the pursuant to the order dated 2/5/2026. The petitioners have filed a comprehensive affidavit disclosing the criminal antecedents. The advance copy of the same has been supplied to the State Council, who shall verify the same and file a report. Please the matter. Yes. Verify and tell me. Yes. Yes.
24.
madam
May I please your lordship, madam?
Verification. After verification of your affidavit.
And the basic
day
Yes,
after
next.
day after tomorrow
Next week.
Not day after tomorrow. It will take little
Next
time.
week.
Huh?
Next week.
Next week. Yes. What is the great urgency? You have so many cases. Yes.
24.
may I please your lordship, madam? I am the
Yes.
basic, madam. Sorry.
Yes, sir.
Madam, petitioner is a lady in custody since 2/3/26.
2/3?
Allegation of 2/3/26, madam.
Yes.
And she was a passenger. The co-accused person has been granted bail, madam, by B and C.
What about
flag B and-
what about the antecedent?
No antecedent, madam.
Where have you said?
I have said, madam, in my petition, madam.
Okay. How much is this recovered?
22 kg,
Nice.
madam.
Huh?
22 kg.
Not from her possession.
ଅଟୋରେ ଯାଉଥିଲେ
In
ସମସ୍ତେ
the
ବସିଲେ।
auto, madam.
Petition is
And the co-accused person is granted bail, madam, B and C. madam.
22 CBF 171 recovered from an auto in which the petitioner is also
Was a passenger, madam.
was a passenger. Was a passenger. And the petitioner is a lady. What is this? 36-year-old lady, and she doesn't have any criminality. He has been in custody since 2/3/2023. Subject to verification, granted. Yes.
Obliged.
25.
What about the other one?
Other one, he is there.
I am appearing for him.
He is also, what about the antecedent?
No antecedents.
Where have you said that? She is a lady. What about you? Where have you said that?
In my petition, I have in paragraph 10, madam.
I'm not asking you. Where have you said, sir, you don't have antecedent? A clean antecedents. Yes, para 9. Para 9 is clean antecedent. Subject to verification. Yes.
Obliged.
Next.
25.
I think 25 my lord. I need some more time to furnish the comprehensive affidavit. Because the lordship is directed.
You want to file, huh?
Yes, my lord. Five
Pursuant to
cases.
the order dated 2/5/2026, the petitioner could not file comprehensive affidavit in 6 adjournment. Please see matter. Yes.
26.
May I please the lordship?
Weeks after vacation.
May I please the lordship?
Yes, yes.
I'm appearing through VC Sambalpur, my lord.
Yes.
My lord, I have filed a comprehensive affidavit with regard to their his criminal antecedent and address, my lord.
Where is the affidavit?
From Bihar and 106 kg.
105 kg, my lord.
105.
My lord, I have yesterday only, my lord, another BLAPL has been disposed in the court of Hon'Ble Justice Sibo Sankar Mishra, my lord, by
BLAPL number 4212 of 2026.
Where is the affidavit? The affidavit has not come on record, madam.
My lord,
When have you filed? When have you filed that?
today only, my lord, because her wife
Today only
has
you
not
file. Okay. And you file that order also if you want, you seek parity, you
My
file
lord,
that order.
before, as withdrawn, my lord, because
No,
bail
withdrawn.
not granted there. Only, my lord,
You
trial,
want to withdraw what? Are you interested to withdraw it?
not my lord.
Then why are you citing a case where it is already been withdrawn? Anyway, you file the affidavit.
I have filed it, my lord, already filed.
How much is recovered?
105.
105, right, pursuant to the order
Therefore,
dated 5/2026. Land counsel for the petitioner submits that pursuant to the order shown. So she has already filed comprehensive affidavit, which is not in place on record. They seek to locate and place it on record. She has also pointed out that what is the relevancy of this?
Which?
My lord,
In
Maybe
March
so.
26, she had filed this BLAPL and withdrawn.
not my lord. Yesterday only, 4212. 4212
And
2000.
March also, madam, March
March
also 18/3/26 also you had filed.
That is disposed, my lord. As rejected. Rejected.
It was rejected. How many cases you filed?
Twice. Successive.
This is third time. Right.
No. For this petitioner, my lord, I have not filed any
Anush
application.
Madam, just see, Sanoj Khatua has filed BLAPL number 8880 of 2026, which has been rejected on 18/3/26.
My
Thereafter, the same petitioner filed another petition, which has been withdrawn now on 11/5/2026.
My
And the
lord.
present one is the third one.
No, my lord. This is only for the
Prasad.
another accused person, my lord. This is not for the son of
Lakshman Prasad Singh. Lakshman Prasad.
Different, but at the same time, similar
It's a Bihar.
persons
My lord.
and similarly circumstance person has already been rejected. So
Not rejected, my lord, as withdrawn because my lord land district land second.
no orders.
Okay, you let the file, let it come
Second,
after
my lord.
vacation. You file affidavit with the verification of the affidavit and this. So, yes. Okay, next.
27. Next may be granted of previous order.
Yes.
Direct me to file an affidavit.
Is that he has got oral instruction that the petitioner no criminalization for the defense that the petitioner has been proceedings. 725 with the recovered confirmed is only 32 gram of brown sugar. And
Yeah.
it is less than commercial continue for yes.
The affidavit is flag B.
Yes. Pursuant to the matter was heard on 4/5/2026 and the following order was passed. Pursuant to the said orders. Where is that affidavit?
Flag B.
Flag B.
Yes, ma'am.
Pursuant to the aforementioned order. On
Paragraph 3 declaration, there is no case.
A comprehensive affidavit has been filed in Trelia stating age under. Which para?
3 years.
Para 3. Para. Petitioner is in custody since
Since your lord is 17/11/2025.
17/11/2025. Daily petition shown so regarding to information. State council opposite affidavit. The recovery is only 35 grams, na?
32 grams.
32 grams of brown sugar. Quantity of contraband recovered, period of custody, and clean liquid. Subject to verification. Yes. Next.
Obliges.
28.
For the last occasion, my lord was pleased to direct it to file the comprehensive affidavit. I've already filed, that is flag B, my lord. Petition number 1 and 2, both have filed the affidavit, my lord. Only 90-80 grams below commercial quantity, my lord.
Yes, criminal antecedent.
Antecedents are there.
Yes, my lord. Not similar at accident, my lord. That is one is 420/34 IP, petition number 1. For
Similar antecedents are there. Custody since?
custody since 9/3/2026,
Less than commercial quantity.
my lord.
Right of petition. Simply कर दो. 4/5/2026 नहीं देखिए वो first
And the charge sheet is also filed.
this around 4/5
Final PR.
following order was passed. Pursuant to the state order, the affidavit has been filed on 6/5/2026 inter alia sitting a general. Para 4 na?
My lord.
Para 4, inter alia. For the petitioner submits that although the petitioner has one criminal antecedent, but the antecedent is not of similar nature. Similar nature. Allegation against the petitioner shown so, and the recovery is 98 grams of brown sugar, and custody since 9/3/2026 subject to verification granted. Yes. Yes.
29.
That's praying for Passover.
Password. Okay.
Item 30.
Yeah, please, Lordship, my lords, on behalf of Miss.
Sorry?
On behalf of Miss Bharti Maiti.
Yes, yes.
My lords. My lords, in this case, my lord, the
Have you filed the affidavit?
My lords, I have already
Yes.
filed, my lord. In para 4, I have mentioned that, submitted that
Yes.
there is no.
But what is the recovery?
24 kilograms of,
20?
24 kg of ganjas from the, from
Custody
the,
since
11/10/2025.
11/10?
2025, my lord.
11/10?
My lords.
24?
25,
25.
2025.
What is this says?
Charge.
Outside, right? Yes, madam.
Only 24 kg and is a local district.
Local and I think that
Can be those.
persons, the metro persons, the order dated 4/5/2023, the comprehensive affidavit has been filed in para 4. Para 4, na?
My lord.
Para 4 of the affidavit is stated as under. The allegation against so. Recovery is 24 kg of contraband ganja. Custody since 11/10/2025, resulting at the period of custody and so he shall appear in the court and so. Yes.
31.
DPO, please.
On behalf of Mr. Mahapatra, Lordship, I admit permit.
Yes.
I have filed an affidavit on
filed?
seat. Yes, Your Lordship. But this is a case, Your Lordship, where is an allegation on 4/1/2025.
On this affidavit, Your Worship.
Sorry?
I have to take instruction on this affidavit.
And then let me submit, my lord, only one submit.
Let her verify. Why to
6 months after, Your Lordship, the FIR is lost. All are on anticipatory bail.
Let us see. Pursuant to the order dated 6/5/2020, a comprehensive affidavit has been filed.
On 8/5.
Who has filed it? Wife of the
Wife.
petitioner. Wife of the petitioner on
8/5.
on 8/5/2026. Let counsel for the state seek judgment to verify the contents of the veracity of the contents of the affidavit. Lease the matter on subject. Yes. Before
My
we
lord,
execute. Yes.
My lord, all are on anticipatory bail. Your Lordship may call it tomorrow, day after tomorrow, it is.
I'll
I
request
don't-
some time to verify
Since-
from the.
Verify next week. Next week karte hain, next week.
It belongs to Sundargarh PS.
True, but I have annexed the anticipatory bail order, my lord. Since 1 year we are in custody.
Next week, 1 year, 1 week. How does it make?
Next week, Your Worship.
ନାଇଁ ଡେ ଆଫ୍ଟର ଟୁମରୋ ଆସୁ ଦେଲିଣି 7 ଦିନ ହେଲାଣି 5 ଦିନ ହେଲାଣି ଦେଲିଣି
8 ତାରିଖରେ ଆପଣ ଫାଇଲ kale to.
He wants that
for
next.
Monday.
He wants that you don't enjoy the vacation before 1 week. You come next week. Okay.
ନାଇଁ 15 ତାରିଖ ଆଜ୍ଞା ଆସୁ
15 ତ କରିପାରିବେ 15 ହେଇପାରିବ। Let it be 19th, 18th or 19th.
18th.
18th. 18th. Okay.
Obliged.
Yes.
32.
32, my lord, I have filed IA for modification.
Sorry?
I have filed IA for modification of order.
What modification?
Paragraph 7, your lordship said that subject to verification similar antecedents. He has 2 similar antecedents.
Similar only it is written.
I mean, he has 2 similar antecedents.
And then we are not entitled to anticipatory.
My lord, the co-accused,
Not
on the basis of whose
You
statement.
see, you persuaded the court saying that I have no criminal incident, and thereafter no. No,
My
right
lord,
on.
my lord,
The by order dated 27/4/2026, the petitioner's anticipatory bail application being 3406 of 2026 was allowed, and the following order was passed. Para 7. By way of the present modification application, and counsel for the petitioner submits that the petitioner has 2 criminal similar nature of criminal incident. Therefore, the condition imposed by this court for while granting anticipatory bail, for subject to verification of the similar antecedent of similar nature, he shall be maybe modified. Since the petitioner has fairly disclosed that he has two criminal antecedents, petitioner is not entitled to grant of anticipatory bail. However, it is open for the petitioner to surrender, and the bail application shall be decided on the same day. Yes.
And parity may be considered because the co-accused has been released.
He further submits that the co-accused, all the co-accused, how many?
Two accused persons. The arrested accused.
The co-accused person, what is the name?
Pankaj Nayak.
Pankaj
Nayak.
Pankaj Nayak has already been enlarged on regular bail.
Regular bail by the district court.
Regular by the court below, and so he is entitled to parity. It is open for the petitioner to take the ground of parity along with besides the grounds already heard in this petition. Your anticipatory bail was granted, so therefore you will get it. No problem. Yes, I modified. Yes.
34.
30?
34.
Okay, 34. Yes. Yes, 34. Yes, sir.
Actually, I am for the first party in this now.
You are appealing for petitioner.
I'm there for the petition, my lords, on
Yeah.
behalf of Mr. Panda, my lords.
Ah.
My lords, this matter, there are two other similar matters, my lords, arising out of the same cause of actions and the same parties, my lords. I believe all the four of the CLMCs may be taken up together.
Madam, this is now selectively listed before me. I can't help it. I have to either dispose it up or adjourn it or something. But these matters are not to be adjourned. That's the reason it is listed. Because some interim order is going on and on and on from 2022.
I pray for a passover.
I can pass it
Mr.
to
Panda will be.
argue it. And what about the other? What is this matter? Let me understand first.
Negotiable instruments, sir.
Yes.
Reliance of the.
You are the complainant.
I am the proponent. So proceeding has been serious in 2000. Yes, difficulty. We can maximum take up.
What is the check amount?
Pardon?
Check amount. Amount of the check.
48 lakhs.
14 lakhs.
48 lakhs.
48 lakhs. And what about the other connected matters?
Two matters. Two.
No, what about the other in this matter?
These two matters I think 48 lakhs.
48 lakhs. And what about the other matters?
But it's just similar, same. It is with regard to four letter of intents that
There are 4 checks.
Yes, my lords.
4 checks.
In regard to all the 4 checks, 4 cases are there.
Yes, my lords.
And we will decide it. The other 3 cases, you will get the advantage if you are
Before my lords. 2 are before my lords listed today.
today.
Yes, my lords.
Argue it today. We will dispose it.
My lords, I'm praying for just pass.
Yes, I'll pass it on. No problem. Argue. Because 2022 in a Negotiable Instrument Act, you have taken a stay order and going on. And this will go on for another 20 years.
It was there before, listed before the pre-lok adalat, my lords, as well.
Yes.
Mr. Panda is busy, so that's when he's.
I'll pass it over. Huh?
Yes.
Let Mr. Ponda come. You have any problem?
No problem.
Okay, let it come. Yes.
We can keep it maximum to next week. Not if it is tagged, then it can.
See, next week, last week, these kind of matters will take time. Today, if it is possible, we will do it. Very stuff. Yes. Next.
35.
35 also pass over.
Yes.
Same.
36.
The defect are removing.
Yes. Yes, madam. What is this matter?
Defect are removing.
The defect pointed out by the registry by the SR has not been complied with. The matter was actually listed on 16/5/2023, and none appeared for the petitioner, and the matter was adjourned. When the matter is taken up today, none appeared for the petitioner. It appears the petitioner is not interested in the proceedings and dismissed. Yes.
37.
37, my lords, I appear for the petitioner, my lords. Petitioner here is challenging an order of cognizance, my lords, on dated 13/4/2022, as well as the entire criminal proceedings. It's a matter pertaining to NI Act, my lords. My lords, the brief facts and the only issue which the petitioner is pressing here is that, my lords, a check has never been issued by the petitioner, despite the not issuance of a check.
These are the issues to be decided in trial. What cognizance order do you?
My lords, probative value of evidence, my lords may come once to my lords page 18 for a moment.
No, at this stage of cognizance in a 138 matter, why should the court will interfere?
My lord, there are multiple judgments of the Supreme Court, my lord. There are no grounds made out also, my lords, because the petitioner is the company, my lords. My lords,
Show me the complaint. Show me the complaint.
My lords, I'll show the complaint. But before proceeding to the complaint, my lords may come on to page 18 for the of the page 18 of the 18.
Okay. Yes.
But page 18 is the annexure 2. These are the checks, my lords. These checks are being issued by one person named Sushant Kumar Panda, my lords. Correct, my lords. My lords may come to the complaint, my lords. Annexure 3, page 21, my lords.
21.
My lords. The accused is Thrice Agarnath Construction Private Limited, my lords. And the averments, whatever is been raised in the entire complaint is directed towards the accused Sushant Kumar Panda, my lords, not the company. This is what is the sole ground that has been taken out by the petitioner, my lords.
Yes.
My lords, in fact, in page 22, the averments are there, my lords.
Where is the averment? In the capacity of managing director of the company, have you issued? The accused is the managing director of company. Yes. What do you say?
Yes, Lordship, kindly turn to page 22.
22.
Yes. Paragraph C.
Paragraph 6.
C.
Okay.
No.
Read it.
So far as complainant is concerned, the accused has issued 4 checks amounting to 17 lakhs, out of which 1 check has been honored.
No. What he's saying is Sushant Kumar has issued the check.
Yes.
He may be MD, he may be whatever. And you are prosecuting the company.
Lord, my inter-averments in the complaint petition is that Sushant
Where you
Kumar
said that in the capacity of managing director of the so-and-so company,
Lord,
the
only
check was issued. Show me.
Only in the cause title, no other averments in the
Then
petition.
it's on. You will not succeed.
Lord,
it's a wastage of time.
Lord, so far as all these things are concerned, they have also cited one of the judgment. They have filed along with the.
Then you don't have a case, sir. That
I have to verify that judgment because.
What will you verify this?
Lord,
it's apparent.
On the one hand,
just see the check. Check is issued by Sushant Kumar. Okay,
my lord.
And there is no seal also.
No.
There is no company.
No.
You should have prosecuted Sushant. Instead of that, you are prosecuting.
On the one hand, he has said, I have issued the check on my personal capacity, but he has issued the check.
Lord, where in the complaint, at least you should have made the averment that he is the managing director. The liability is for the company.
Not there in the complaint.
In lieu of that, it was issued.
That's right. That is not there in the complaint.
I'll pass your. Yes. What are the judgment you are citing, sir?
My lord, 2 judgments, my lord. PG Agrotech and Mainuddin Abdul Sattar, my lord. These are landmark 2010-12 SEC 146. I have filed a memo of citations, my lord.
Which paragraph?
My lord, paragraph, my lord. Page 5 of the compendium, my lords. Paragraph 13 and 14, my lords.
Yes.
My lords. The next judgment is, my lords, Mainuddin Abdul Sattar Sheikh, my lords. My lords, paragraph is 11 and 12, my lords.
Have you filed any recovery proceeding? Recovery
No,
also?
no.
See you. That's the whole difficulty. Okay, I'll pass your.
No, only so far as the status of the accused is concerned, that is mentioned only paragraph B, page 20.
Paragraph
B.
Okay.
The accused is a managing director of Thrice Agarnath Construction.
He may be managing director. Where have you said that the liability of the
that
company?
is not there. Save and accept this.
Unless you make a specific averment saying that the check was issued in lieu of discharge of the liability of the company and he is the managing director. Then
Save and accept paragraph B, no other.
Company is a juristic person. You can't prosecute a company like this.
But so from the
averment is problematic and everything is problem.
So far as other checks are concerned, he has also, I have issued 4 checks. He has issued 4 checks. 1 has been encashed by me out of 17. Other 3 has been dishonored. On the same capacity, one check has been encashed by the present complainant. That is also
And
avoid.
show me your notice under 130 statutory notice. Do you have that? Notice was issued to individual capacity or there also you may
No.
have something.
That is on the cause title as it appears annexure 3, page 21.
Give me your notice.
Notice.
I want to help you out.
Notice is not with me. Like,
Come with the notice. If you
Ma'am.
have issued notice, in the notice also you have made the environment. Then
Ma'am.
also you have a saving grace.
man.
Notice
I'll
is not mentioned, my lords. It's not mentioned. It's directly
I'll
issued.
produce that.
It is directly issued to the company only.
Notice was also issued to company.
Company only.
I mean, allowed to produce that notice. Madam.
Come tomorrow. Come with the notice. Let's see.
Lord, one day more. One day more.
No, these matters
Madam.
outright it will be dismissed. Yes, there is nothing in this matter. Yes,
My lords, interim order to continue.
interim order will be there tomorrow only. Yes, next.
38.
Wait, please, Your Lordship. Old matter, Your Lordship. I do not have any contact with the petitioner. Even the other party who is appearing, he doesn't have a copy. I said that whether if you know something about the petitioner, you tell me. I have.
You are for petitioner.
Again, absolutely. I could not even. I tried to contact the learned advocate in the lower court. He also said that since 1.5 years he has no contact with the.
4 matters, huh?
No, again, got to.
1 matter.
Yes, Your Lordship.
Okay.
38.
Then you think that you have not appeared. I will dismiss you for non-prosecution. Non-appears for the petitioner.
I'm for
Dismiss
the-
for non-
No, I'm for the petitioner, my lord.
You think that you have not appeared. I will dismiss you.
No, my lord, Your Lordship may record my submission that I have no contact with the petitioner, no instruction from the side of the.
Right, Mr. Mishra and counsel for the petitioner submits that although the matter is pending since 2022, but he has no contact with his client. And the instructing counsel has also lost contact with the petitioner.
Petitioner.
In view of the same, he is unable to assist this court
My lord.
regarding the statement made by the petitioner. I am also, this court is of the view that the petitioner is not interested to proceed with the matter, hence this was henceforth non-prosecution. Yes. Problem.
39.
Yes. 39.
Item 39, matter has infructuous, my lord. Evidence already been
And
taken.
counsel for the petitioner submits that the matter has become infructuous and dismissed as infructuous. Yes.
Item 40.
Just protect.
40.
Item number 39, that I am appearing for the opposite party. Well, that is his submission, but I have no instructions about the closure of the evidence.
But it is his. I am recording his statement. Yes.
Item 40.
May it please, Your Lordship.
Yes.
I am for the petitioner in this case. It's a check bounce case. I am accused, Your Lordship. There is a settlement between the parties. Out of 25 lakhs, I have paid 10,50,000. It is admitted by the complainant. Your Lordship may kindly permit me to place the interim order dated 22/12/2022. That is order number 1 and 2.
Yes.
On my submission also, it has been recorded that there is a likelihood of settlement because out of.
See, 22, this matter is pending. The order is just see how many years.
Yes, Your Lordship.
If you have intention to pay, you will pay it. If you don't have
My
intention.
prayer is that, Your Lordship, let it come to mediation. Let both the parties come, matter can be resolved.
See, you have to pay interest also. See, you can't take stay order and for 6 years you sit down and don't pay.
I contacted, because the matter is listed, Your Lordship, thereafter, I contacted him. If anything resolved between the parties, because out of 25 lakhs.
Call him tomorrow. Petitioner. Let the petitioner
Tomorrow again, possible. Next
appear.
week.
Day after. Call him. These kind of people should not be spared. See, judicial system is clogged because of this.
No, my prayer is that before Your Lordship, that my learned senior appearing for the complainant also, there is an averment in the complaint that out of 25 lakhs, 10,50,000 paid. Thereafter, one arbitration case is filed, another 1cc case is filed. Those were required to be withdrawn. Those.
So far, let me say. So far, arbitration petition is concerned, I had filed that under section 11 Honorable Chief Justice was pleased to appoint an arbitrator. Milords, thereafter, Milords, he did not cooperate. Simti Royala, Tiche Hitanans.
The intention is
Did not take up.
intention is bad.
I was not the lawyer in that case.
Intention is bad. Call him.
2014 Milords.
I'll
That
set,
arbitrator-
let the party be present here. I'll
Both
settle it.
parties.
Both the parties.
Yes.
We'll settle here only. We'll appoint someone. Big burden for you also.
No, I have no objection. If you-
Because see, the arbitration and everything will be settled here.
that is my prayer, my lord.
We'll
That
settle
is-
it. Don't worry. Bring
That
them.
if anything is possible between them, because they were doing business.
Let them come. We'll settle everything.
Lord,
10
so-
lakh he has paid. There may be some financial
Yes, sir.
uncertainty. We'll fix insolvent or something we'll do. See, as it is 4 years. 4 years.
Not cooperating at all.
No, no,
Let us
10 lakh
think.
10,50,000 से देना जी.
10,50,000 देंगे.
That is there.
Payment you expect positive. Let us.
Your lordship may call it on 18th, your lordship.
Let the parties, let both the petitioner and respondent shall appear in court. On 18th.
Again.
Let them come. We'll sort it out.
The interim order may continue.
Interim order. That interim order is the only problem.
नहीं आगे मुंह दे जो लोग 10 लाख
Interim
50,000
order
दिन.
that will settle जाना.
Today even
That is the
I
reason I am reluctant to pass interim order.
नहीं, your lordship may call it on 18th. If your lordship will realize that
I'll vacate and dismiss it out.
if your lordship will realize that the matter can be settled
It
on
can
that
be.
day.
It can be. I think it can be because
Because
10
10
lakhs
lakhs-
he has paid. So therefore.
And
maybe
both were friends doing business, this land selling business together. Thereafter the dispute arose.
we'll do it. It will be settled. Don't worry. Yes.
18th, your lordship, the interim order.
18th.
Till 18th.
18th. Interim order to continue. 18th parties to appear in first.
Again.
Yes. Seven kona Huh? Disposal. Some of order maybe in your favor only. Yes. Next. Password. Password. Huh? Okay. I have already passed the order, sir. I don't know what order I passed, but may be favorable to you only because the others have passed negative orders. If you want, then I'll review that order. Yes. Please. Start. कौन है टाइम दीतला जिमा ऑर्डर है फर्स्ट ऑर्डर देखो जिमा ऑर्डर हाँ जिमा ऑर्डर है किस्टम रिपोर्ट रिमूव विद इन 2 weeks इसी ऑर्डर से करथिला जिमा ऑर्डर लिखते हो तापर सी नोटिफिकेशन पब्लिश इसको 46 46 yes I for and the other 3 matters which you know कोई भी थोड़ा कोई एक तीन चार मैटर हां फिर ना ऐसी this matter was because from matter 25 matter.
Item 51.
He has filed the application
To
for application for dispensation. Application for dispensation. Madam, by order dated 2/9/2025, the petitioner was granted 2 weeks time to cure the defect. Also, the petitioner submits that he has filed an application being IA number 14272 of 2025 and seeking dispensation of filing certificate copy for the annexes. Annexes, the application, for the reasons stated in the application, the same is allowed. Leaves the matter for hearing before the court next week. Next week. And the photocopy is there?
Sir, order
1 minute. Photocopies are there? No. He says that page number 43, 45, 46, 49. Those things are visible. 46. Just see. 46. Let's see.
46 legible.
Not legible at all.
46 টা legible. Page 46. Marking.
Not legible, therefore,
Page marking is page 46 ଟା. Page 59 ରହୁଛି.
no. Let's see. Not legible.
ହଁ ତାପରେ 49 legible ରହୁଛି. 49 ଟା legible.
The application is allowed, subject to the petitioner filing typed copy of the page number 43, 45, 46, and 49 of the writ petition, within a period of 3 days from today. In the event the typed copy of the said pages are not filed within the stipulated time frame, the writ petition stands dismissed without reference to the court. So these are the not legible copies. So he asked for dispensation. Typed copy is to file. Yes, next.
Sir, 51, sir, 51, 52, 69, 75, and 83. There is no such defects, neither the court fees, shortage of court fee, nor filing any document area which is relevant. Only some minor defect, name of the father is not there or something like this. It may be ignored and also listed for admission.
No. What are the defects?
Minor defects, sir.
Let us see first one.
Yes, sir, 51.
51.
Yes.
What is the defect? Minor defect, why don't you cure? This is Jima has passed the order in 2025.
Sir, difficulties I show. Suppose we go to the SR, they are demanding money. It is number one. Number two, there is a very rush because the non-availability of the manpower there. So it is very, very difficult.
The order was on 2/12/2025, giving you time for 2 weeks to cure the defects.
These are the, sir,
maybe minor, but
sir, minor defect. If my lord, please just to
I can't ignore. What are the defects? First,
please see, please.
Let us see what kind of minor
Yes,
defect.
yes.
What is the defect? Show me. What is the defect?
Legible.
What is the defect in first item?
Yes. No.
You say minor, you don't know even the defects.
Code number not mentioned.
Code number. Code number not mentioned. Code number.
Cure the defects. Right?
Sir.
All matters, I am giving further time to you. Cure the defect.
Only 1 week. Because next I should made a mention.
It's so 2 weeks time was granted by Jima to cure the defect. How position is not taken cure. Mr. Panda appearing for the petitioner seeks 1 week to cure the defect. Let him do so within 1 week from today. And even the defects are not cured, will be yes, 1 week time.
Sir,
which item you said? 51?
51, 52. Then 69.
69.
75 and 83.
The number.
Sir.
Okay. Any other man?
My lord, item 68, my lord.
68. Yes, sir.
I have removed the defect, but I have not paid only 10 rupees court fees, LA court fees.
Okay.
That is in the Working Code of Colony.
By the order dated 12/2/26, the Jima granted 3 weeks time to file the deputy registered Jima. 2 weeks time, 3 weeks time to cure the defects, which has not yet been cured. Then counsel for the petitioner, 1 week time to cure the defect. 1 week time has been granted to cure the defects from today. In the event the defects are not cured within 1 week, the writ petition stands dismissed without reference to the court. Yes, 1 week time I grant. Yes. 50? Yes.
I am on behalf of convent.
1 week time. 1 week time. 1 week time.
Item 62.
62. Same. One week. The 1 week.
62. I may be pardoned, item 40.
1 minute. See, let us see. Page by page. 1 minute. Page by will. Serial wise.
Item 41.
43 permitted to withdraw, my lord.
43 withdraw. Yes.
44.
41 dismissal. 44. Dismissed. Yes.
45,
Dismissed. Yes.
47,
My lord, I am on behalf of Mr. Mahapatra. Hello, one
Yes.
week time maybe.
One
One
week
week time may be given to.
Demand order without reference to the court. Yes. Next.
48,
Okay.
48, my lord, permit to withdraw.
Withdraw. 48 withdraw. Yes.
49,
Dismissed. Dismissed.
50,
Your Lordship, 1 week time to remove the division.
51 week time without reference to the court. Yes.
53,
Dismissed.
54,
Dismissed.
55,
Dismissed.
56,
Same. Dismissed.
57,
Dismissed.
58,
Dismissed.
49 बाहर देखो तो बाहर 41 चलती है
Yeah, leisurely you are coming. 49 kono 1 week time. 49 1 week time. Yes.
49
Yes. Next.
58,
Dismiss.
59,
One time.
1 week time. Yes.
60,
Your Lordship, I may be permitted to wait.
Withdraw. 60 withdraw. Yes.
61,
Dismiss.
63,
permitted to withdraw money.
Withdraw.
65,
This one. You will dismiss for the non-appeal for. Yes.
66,
Dismiss.
67,
1 time.
1 week time. Huh? 1 week. Yes.
70,
Dismiss.
71,
Dismiss.
72,
Dismiss.
73,
Dismiss.
74,
It's time for the removal of the pet.
2 week. 1 week time. 1 week time. Yes.
76,
Dismiss.
77,
Dismiss.
78,
Dismiss.
79,
Dismiss.
80,
May I please, Your Lordship? I am appearing through virtual court, Your Lordship.
Yes.
The notings, in the noting only page number 27 was highlighted.
Okay. I'm giving 1 week time.
Lordship, I filed it today. I've already filed it today.
1 week time, it's all right. 1 week time is granted. Yes.
81,
Dismiss.
82,
1 week time. 82 1 week time. Yes.
83,
Dismiss.
84,
Dismiss.
85,
Dismiss.
86,
Dismiss.
87,
Five copies of page 87 and 45 page. Legible form.
I kindly be produced and file copy of the page which are not legible. Which is filing will not legible. Let us see. File going. 45 is flag B. Not legible. 1 week time granted for filing type copy of the illegible pages. Illegible pages. 1 week time. Yes.
88,
Yes. Dismiss.
89,
Dismiss.
90,
Dismiss. Yes.
The password.
Password.
item 21,
No, I password.
So what is this matter? The board is complete. So shall I come after? I'll start hearing regular matters. All 90 matters. Keep it up, please. Three passwords are there. I'll take it up.
Details.
Any regular matter?
Seven dimension quickly.
Some
form dimension from 3 dimensions. How should I say?
We'll start some regular matter. Yes, you are ready. In which matter you are ready? In regular matter. Weekly list.
For the weekly list.
Anyone is ready? What is ready? Yes. Which item?
85. That pattern.
85 last.
85. Who is appearing for? 85. Anybody is ready? 85. It's a parted matter he wants for.
report that has not been we must
appeal as soon as
85.
yes
এটা pattern on special assignment to
ଆଗରୁ pattern ଥିଲା
ନା ନା pattern ମାଇଲର ପାଖରେ ଆଉ କୋ ଏଟା specially assigned to ମାଇଲର
pattern ପରେ ଆଉ ଚାରଟା ଅର୍ଡର ହେଇଛି ତା ଦେହରେ pattern ହେଇଛି ସେ pattern ତ ଧରିକି ଏଟା କହୁଛନ୍ତି ଏବେ
See, the problem is I have noted down all the arguments, so it can be disposed of. That's the idea. That's the idea. If you are not ready, that's a different story. But it is partly heard. He is pointing out only one issue. That issue has to be sorted out.
42 non-compliant.
Non-compliance. 42.
No, what he is submitting that the officer.
No, the trial court says that 42 is not applicable. 43 is applicable. He came with a judgment saying that no, 42 is applicable.
That is not.
Whether 42 is complied or not.
His contention that 42 is applicable. He is submitting that the officer received the information. He has to reduce it in writing. That is an absurd proposition.
No.
Somebody is in patrolling duty. How can he reduce the information into writing? So
That is again appreciation of evidence. No.
Contention raised by
Yes. That is the only issue.
That is
Where
the only
42 is applicable or 43. Now he has shown me the judgment saying that is no, 42 is applicable. It's all right. Whether 42 is complied or not, that is again appreciation of evidence.
Yes, that will made out. Then I have no case. ମୁଁ ତ କହୁଛି 42 ଖାଲି କଣ କର ସେ information ଟା receive କରିଦେଲେ ହବ କି? ତା 42 କାହା କମିଟି ଓଭର ଦେଲେ ମୁଁ totally non compliance of the party.
No, that was reduced to writing.
Na reduced to writing will
From evidence you have to show me that.
Yes.
That is there.
Nah, that has not been communicated to the superior authority and whom will not in the office of the superior authority that the IIC reduced the writing there. He has not been examined and that has been communicated to whom? He has not been any official staffs of the Millard superior authority officer has not been Millard made out. In a clear case of Millard 2018-17 OCR, Gudhiram, Muduli and another totally applicable in this case in a public place.
Where is that judgment? Give it to Mr. Pani.
Paragraph 8 to 30.
Show me that judgment. Let us see.
Paragraph 8 to 30. How Millard
42
compliance.
Para
8.
Start reading. Yes.
8%. Adverting to the contention regarding Millard compliance of the provision under section 42 of the NDPS Act in case of state of Rajasthan versus the
While discussing regarding the compliance of 42 of NDPS Act,
Gagrat Singh and Hansen reported in so and so while discussing regarding the compliance of section 42 of the NDPS Act in case of vehicle which was seized at the public place carrying contraband articles, it was held that since the jeep cannot be said to be public conveyance with the meaning of the explanation of section 42 of the NDPS Act, hence section 43 was clearly not attracted and provisions of section 42(1) proviso were required to be complied. First, my lord, is similar to with me in a
Yes.
public place privately.
Yes.
And it was further held that the aforesaid statutory mandatory provisions having not complied with, the High Court did not commit any error in set aside the conviction. The present case is not a case where PW4 suddenly carried out search in the vehicle at a public place. PW4 himself stated that he received the reliable information regarding transportation of ganja in a Bolero vehicle, and he has come up with a case, compliance of section 42 of the NDPX Act. There is no material that the offending vehicle comes with a public conveyance, and when search was conducted after recording information under section 42(1), therefore, even though the detention was made during night and seizure was made in a public place during daytime, compliance of the provision of section 42 of the NDPX Act is mandatory. The Honorable Supreme Court, while discussing the provision under section 42 of the NDPX Act, in case of State of Punjab versus Balbir Singh, reported in 1994, 7 OCR SC 283 has been pleaded to hold that the object of NDPX Act is to make stringent provisions for control and regulation of operations relating to those drugs and substances. At that same time, to avoid harm to the innocent persons and to avoid abuse the provisions by the officers, certain safeguards and provided which in the context have to be observed strictly. Therefore, these provisions make it obligatory and that such of those offences mentioned therein on receiving information to reduce the same in writing and also record regimes for the benefit while carrying out arrest of such as provided under the provisions under section 42(1). To that extent, they are mandatory. Consequently, the failure of comply with these requirements, such aspects the prosecution case, and therefore vitiates the trial. The decision rendered in the case of Balbir Singh Supra was further considered by 5 judge benches in case of Cornell Singh versus State of Haryana. This is the Milord guideline how it complied. Then it's not necessary to. Then Milord instance case, Milord. In view of this, then Milord, same paragraph, Milord, last second page. In view of the settled position of law, now it to be seen whether the contention read by the Lorraine Council for the appellant, there is non-compliance of mandatory provision under section 42(1) and 42(2) of the NDPX Act is sustainable or not. In the first information report, Exhibit 10, the inspector in charge, Potangi Police Station, PW14, has mentioned that when he received a reliable information at so-and-so regarding transportation of ganja in a Bolero vehicle bearing registration number OR02 AS0344 from Koraput side towards Miller Salur, he noted the fact Bhide PSSD Bhide ST number Miller entry number 68 of dated so-and-so, and he believed that there would be delay caused in obtaining a search warrant which would facilitate the accused person to escape with the contraband ganja, and he thought it prudent to conduct raid without obtaining a search warrant. Accordingly, he recorded his grounds, belief in the PS station diary, and sent a report to the Superintendent of Police Koraput, who was the immediate superior as per the PS DR number so-and-so. While deposing in court, PW4 has also made similar statement. Though the station diary book and dispatch register of Potangi Police Station was seized under seizure list so-and-so by PW4 along with Malkhana register, but neither the station diary book nor the dispatch register was produced in court during trial. In this case, this, as per the evidence of the IO, this has not been complied. Even the authenticate copies of the station diary and dispatch register were also not produced. Therefore, there was no material before the trial court. Any such entry was in fact been made in view of the mandatory provision of the section 42 of the NDPX Act, the court is required not only verify that the reliable information was taken down in writing, also the grounds of beliefs. The grounds of beliefs was also be recorded as per the second provision of the section 42(1) of the NDPX Act, and copy of the same was sent to the immediate official superior in view of the section
That is
2 of the
42.
42. Last same parameter. PW 4 had stated that he sent a report to the superintendent of police Koraput as per the exhibit C. Those CS number RN Biswat, and in that respect PSDR number so and so was made. The concerned constable, though whom the report under exhibit 6 is stated to have been dispatched, has not been examined. In this case, the IO PW 17 Miller, only in her cross-examination, he stated that he communicated the information regarding the transportation of ganja through a mobile phone to the concerned IAC. Then, the IAC not been.
You say it is reducing in writing is necessary and communication is also necessary.
Also necessary. But
one reducing in writing and two communication.
In this case, what happened? And whom, the communication had to be made. He had to be examined to prove this is the exhibit. I received the same from the so and so. I received the same. But in this case, neither I informant only in his evidence stated that I communicate the information through a mobile phone. But in cross-examination, he had not stated in which mobile phone. Then he stated
number of mobile number, everything.
Not. I could not able to. Then the IIC concerned who made the station diary, he had to be examined to prove the I received the information from the concerned IO PW7. Apart from that, the IIC communicate his higher authority, the SDPO, KSP. But in his office, whom he communicated, he had to be examined. In this case, nobody examined, just like this Gathuram. Then second PW 14 admits that there is no initial.
Then what you are saying is it is not only the mandatory requirement of reducing it down in writing has been done, and communication part is also not proved.
Not been done. Apart from that, if there is a petroleum, the concerned IO could not able to reduce the information apparently too. Then there is a provision in this section. That's why in the 72 gap, after arriving to the police station, he may record the same. He may reduce writing the information.
That is also not done.
Then not instantly you have to write, reduce the information in writing. That's why 72 hours time gap is there. Within 72 hours, the IO. But in this case, that has not been, because in his cross-examination, paragraph 23 stated that after arrival of the police station, I could not reduce the information in writing. Only in examination of chief, he stated that I communicated the information to the IAC. Then IAC not examined whether he made the station diary or not, and whom he communicated. And in other hand, whom the IAC communicated, the superior official staff must have constable or any clerk is there to receive the writing to reduce the information in written information before the concerned staff, official staff are there, but nobody examined in this case. And apart from that,
and the trial court had no occasion to deal with it. Trial court says that 42 is not applicable at all.
Not applicable. Moreover, in trial court, in one paragraph, he stated that since on a bare perusal of the affair, the 42 compliance to some extent happens. But that is also in case of Harrier Monda. Only affair is not the substantial piece of evidence. In affair, he stated that that's why I communicated the same, he reduced the same, that has not been. You have to adduce to that effect the evidence. The 42 is strictly compliant.
Correct. The documents are seized, but those documents are not marked as exhibit. You also will kindly see evidence of PW 18. That even that GP, MP, other things, everything was seized. That was not produced in court or marked as an exhibit. These cases, the public prosecutors who conducted this case, proceedings should be initiated against them.
As the whole difficulty, nothing is there, then how can you? not reducing.
Your lordship, kindly see the evidence of PW 18.
I'll hear you. I will conclude it today. Conclude it today. You just the point which he has raised.
That is correct. I admit it.
Then
This conference. That is not. This is an NDPS case. Nobody will allow me to fill up the lacuna.
whatever is there,
Whatever is
we
there,
can't help it.
Understood his contents. Correct. Your lordship, kindly see the evidence of PW 18.
PW 18.
Yes.
Is the IO. Yes.
IO.
Let us see. 80 item number
85.
85, 18 meter.
85 moment 83 है तो आजकल list.
85.
Aji
85 na?
आज list 85.
There are two matters, I guess.
yes, PW 18 is the IO.
Yes. Let us see.
On Miller.
Yes, yes. Surendra Chat.
On 29/1/2021, I was.
One minute. I'll just let me go there. Yes, Surendra.
Yes.
Yes.
On 29/1.
Which paragraph, sir?
Paragraph 1.
1.
Yes.
On 29/1/2021, I was posted as SI of Town PS Balangir. On that day at about 2 p.m.
Paper book.
SI Bijit Behera presented a written report before IAC Town PS who registered PS case number 68 of 2021 on 20B2C of NDPS Act and directed me to take up investigation. During course of investigation, I visited the spot, prepared the spot map, examined the complainant and other witnesses at the spot, arrested the accused persons, namely Santosh Singh and Ramanand Chaudhary, intimated the family members of the accused persons regarding their arrest, seized one command certificate on production by ASI BN Sadangi, examined other witnesses. On 31/2021, I forwarded the accused persons to the court, produced the seized exhibits before the court. Sample was drawn in court in view of order of the court. The ganja packets by Exhibit A and B were kept in the PS Malkhana, and the sample packets Exhibit A3 and Exhibit B/3 were sent to SFSL Bhubaneswar, and Exhibit A1, Exhibit A2, Exhibit B1, Exhibit B2 were sealed inside Exhibit A and B respectively. On that day at about 7:15 p.m. I seized the extract of GD number 22.
This is important. On that day it's also I seized the extract of GD entry number also.
On the Town PS Balangir, the Malkhana register, volume number so and so, dispatch register of Town PS to 1/1/2021 to 21/1/2021. Command certificate.
What is Balangir? Why Balangir?
This case of Balangir.
That is PS Balangir. That is the state town PS Balangir.
No, it is in the Koraput district. Where is the Balangir?
No,
that is the Balangir.
Case of Balangir.
I was posted SI of PS Balangir.
Judgment of place koli seita.
Sorry. Okay. And that is impression. Yes.
On production by BK Behera and prepared seizure list. I released all those documents in Jimma of SI BK Behera and prepared Jimma Nama. On 31/1/2021 at about 11:05 a.m. I seized the detailed report submitted by IAC Town PS to SDPO Balangir and prepared seizure list. Yes. I released the same report in Jimma of SI BCH Patel and prepared Jimma Nama. I obtained the order copy of Sub-Collector Balangir regarding deputation of Executive Magistrate for seizure of ganja. On 2/2/2021, I seized one command certificate on production by OAPF Ramchandra Bhatra and prepared seizure list. On 10/5/2021, I examined the second owner of the seized vehicle at the PS and seized copies of documents of the vehicle on its production and prepared seizure list. Thereafter, the FIR was marked in paragraph 2.
FIR was marked Exhibit P19. Yes.
Thereafter, this is the spot map exhibit marked Exhibit P20, PW18 and Exhibit P20, PW18 is my signature thereon. Forwarding report. Everything was marked except the GD entries and other things.
One minute. Everything marked.
This is the said Jimanam.
What is not marked? Jimanama.
Jimanama, GD entry and other documents of Town PS marked as Exhibit P22. Exhibit P22 kind. Only that Jimanama was marked.
This is the Jimanama.
Yes.
Detailed report submitted by IAC to SDPO.
That is complaint.
Already marked as Exhibit P10.
They should have.
In my
proved-
signature.
That entry should have been proved by way of an exhibit. But that was not done.
May that is GD list मिलर that is the general duty register मिलर से माने जो जाती पेट्रोलिंग रे सेही गुडाको से सीज करनी कोटे ना एसटी जो स्टेशन डाटा
Initial information which was reduced
Yes,
to writing by
that-
the IAC.
ସେଇଟା ନା
That was not marked
I
as
did
an
it.
That entry.
Yes.
Entry of initial
clear कर दो
information.
PW 17 টা দেখি দেবে মিলর ক্লিয়ার কি
Not exhibited. Not exhibited.
Nowhere he stated that I see the station diet. So the information that could IAC. In look into the Miller evidence of the PW7.
PW 17.
17.
17 para 1.
Yes.
17 para 1.
On Miller 2021, I was posted as SI Town PS.
It's there. I intimated about the information to IIC Town PS.
Yes.
IIC made SG entry.
Yes,
This
yes.
SG entry is not marked.
This entry should have been marked as an exhibit.
That's
That
the
was
photo.
not done. So
This
it is correct
SG entry
that
not
aspect which counts.
not marked.
Apart from that Miller, खाली एसटी एटाको सीज कले कि एग्जिबिट कले हबनी सेटाको आईआईसी पुनी काहाको कम्युनिकेट कले आईआईसी भी एग्जामिन हवा दरकार जे मु ए स्टेशन डाटा लेखिछि बोली इंफॉर्मेशन फ्रॉम दिस PW7 and that to IAC superior authority काहा कम्युनिकेट ताको
Communicate भी करियो.
Communicate
Both
करियो.
things has to be proved.
That then itself the case will go. No meaning in discussing other things.
out of Brazil independent witness support करना है other grounds are there.
Forget about the other ground. One ground is enough for in a NDPS case. Why should you get into all these things?
Yes.
File a written note of submission.
Yes.
By tomorrow.
By tomorrow.
By tomorrow, written note of submission. We file arguments at both the appeals. Judgment is there. On that ground itself, I think we need not go into the other grounds at all.
Yes.
And we will discuss about 42, 43 applicability.
Yes.
42
Because
applicable,
public
not compliant.
private vehicle 42 applicable and 42 not compliance in view of the evidence of the PW 17 and 18.
17 and 18. That's all.
Yes.
Need not go into any other. Okay. Done. Tomorrow. Then first. Written note of submission to file by tomorrow. Are you going to file?
No.
You have pointed out
there.
Yes.
My lord, I have a small prayer, my lord. Item number 29, a small matter. We have no contact with the client since letter written on serve, my lord. If they take instruction, I will place this on Thursday, my lord. The offense is 451. He has acquitted on all other offense, only this offense he has been convicted, my lord. IO has not been examined.
Sentence?
2 months, my lord. Thursday, that is next for telephone instruction. I will place.
So I'll grant PO and finish it.
PO
Thursday, Thursday.
PO karo. 29 na?
29.
Oh. Argument heard. PO.
My 2 point, IO has not been examined and doctor contract.
Whatever see PO, you grant 2 months sentence, how does it make?
Fine.
And any other matter? Yes.
Item 44.
Ms. Maharaja, you have one matter. 44. After lunch? After lunch.
70.
Huh?
70 production.
Oh no. No, just do.
Much.
Now Mr. Ponda is now.
How much?
He has been there in the court for this matter every day. So now he is free, give it to me.
Okay.
Okay.
So item 21.
Make legal. That's here. The offense alleged under sections. That's 294, 420, 468, 471, 506 IPC. That's allegation is that
the informant was defrauded by 30 lakhs, whereas he says that he had availed a loan of rupees 30 lakhs, which he repaid, but he says that bank subsequently demanded 30 lakhs more, my lords. But the FIR runs to 6 pages. After going through all these, I find that he approached the ombudsman, statutory authority under the Reserve Bank of India guidelines. He approached the ombudsman, and ombudsman, he has given a detailed order, So, Lords, may kindly look at that ombudsman's order,
Do you have the order?
My lord, just now I received this, but so far my submission about my senior has no relation with this case, my lord.
The ombudsman is
The allegation in this case is informant paid money to the petitioner. Petitioner, instead of depositing that money in the loan account, misappropriated. This is the allegation.
Seda sir, tikke ombudsman order ru sabu jaga achi, inquiry achi, tikke dekhidele, it will be clear. Page 4, my lord. Page 4.
Shall I take it day after?
My lord.
Day after. Place it on record. Place it. Yes, day after. Yes.
29.
No, my case, you intercept justice. You are repeating. Go for it.
Your lordship, I have to review the criminal antecedents. Charge sheet has already been filed. Investigation is over. Read 18.4, read 19.2, 66 C&D of the ITR.
Yes.
All below 7.
You got the CD?
Yes, my lord. No criminal antecedent. And what the petitioner was doing, he was earlier in a banking service. He has relation, different person. Over phone, he allured the some person, deposit, I will arrange the loan for you, processing fee, you deposit such and such. In this way, he has taken some money.
How much?
7,000 and odd minutes.
No, 7,000 somewhat from one person.
Commission total 7,000.
Commission.
Charge sheet says, I am in custody, my lord, since 28/2/2026. Charge sheet was filed on 28/4.
28. I have not received the copy of the charge sheet.
It is not, in true sense, it is not that cyber crime kind of.
No.
Yes. Okay. It's after investigation, charge sheet in the present case has already been filed on 28/4/2020. Petition into custody since 28/2/2026. These are going to go to the nature of application. That of custody granted. Yes. Yes. Next.
34. 34 and 35. There are two other items, my lord. They all should be taken up together. Relate to the same incident. You not to take them up tomorrow or any other.
No, not the incident. Oh, there is all different checks.
All different checks arise out of the same transaction.
What do you say? Shall I call the other two also? Is there any chance of settlement? Total, as you said, totally 34 lakhs or something.
No, more.
Total, how much? What is the amount involved in all four?
Details we can collect. If Lordship is indicating settlement, I'll be too happy if he can.
Why don't I'll also take my client is at Aligarh, my lord. I'll need some time to take.
No. If you agree, both of you, all the four matters I can call tomorrow and send it to mediation. I'll appoint some senior counsel to mediate and finish.
No mediation is required. We'll take instructions. My lord, we call it next week.
This the matter along with the other matters also. In the meantime, there will be counsels agreeing for the parties and obtaining instruction regarding the mutual settlement. Mutual settlement or exploration of the possibility of mediation. This is the matter on. Then on 19th, you tell me. 19th, Tuesday, you tell me so that accordingly we'll either refer to mediation or it is has to be heard, it will be heard. The other two numbers.
Yes, I am giving.
Yes. Please tell us. Yes. Tuesday. So for the purpose of obtaining instruction. Yes. Matters are arising out of dispute of change the section 139 and the scope of settlement. Yes. Yes. For a week. No. 14?
44 or 44 files.
There was
27.
No, 47. 498A, 304B, and 4 DPA. 7 years, 2 years, and
In that matter, I have a humble prayer before my Lord. I have advanced my argument on behalf of the appellants. To sum up the arguments, my friend is here, Mr. Devasnan Das. He will place and thereafter your Honor will hear from the State Council with a liberty to review that.
yes.
Devasnan.
Look, PW 3, 4, 7, 11, and 12, and 15 are family members.
Family members.
1, 2, 5, 6, 8, 9, and 10 independent witness.
With my lord, sir, none of
13,
the
14, 16 official witness.
yes, madam. None of the independent witness has supported the prosecution case, madam.
Yes.
During course of hearing, my lord wanted to make a query whether there is any materials record to show that that room question was bolted. That query my lord wanted. To substantiate, also lordship also wanted where is material, even if there is any materials in respect in either in police paper or in case diary or anything, my lord. And in this connection, I want to refer my lord's attention the statement of accused which has been recorded in section 161 CRPC, my lord. And that lady accused has specifically, that might be the LCR, my lord. And he has specifically stated that Savitri Acharya, that none of the family members were
One of the accused statement.
accused.
Come to 313. What?
No, not specifically stated 313, my lord.
Then
He has stated on 161.
what will I do with that?
No, that is your lordship wanted to reverse it. 161 service, my lord. That is there, my lord.
313.
No, 13, that aspect is not there, my
Then
lord.
forget it.
That
I will not refer to 116.
The other best witnesses, one is Kalyani, another is the husband of the Kalyani, my lord.
PW?
They have not been examined. They have been cited as a prosecution witness, but they have not been examined because they are the best persons to say.
That is the outlook of the prosecution.
Prosecution.
Whom they will examine or they will not examine.
My lord,
The witnesses, those who have already been examined, independent witnesses, 1, 2, 3, 4, 5, and 6. All the 6 witnesses, according to you, have turned hostile.
Yes, my lord.
But partly they supported the prosecution case. And they lend corroboration to the evidence of the family member 1, 2, 3, 4, 5, 6, 7 witnesses.
Yes, ma'am. My lord, I entirely concede with my lord's view, my lord, that prosecution is obliged to, it is a prerogative on the part of the prosecution to examine witnesses. But prosecution is not obliged to examine some of the independent witnesses and deliberately suppressed most independent and material witnesses for which an adverse inference will be drawn against the prosecution, my lord, under section 114.
An examination of some cited witness
Yes, my lord.
will not discredit the evidence which is already there on record.
Yes, my lord.
How will you discredit them?
Yes, my lord.
That's the issue.
Yes, my lord. With my lord's permission, I am placing a judgment law, my lord. That is a case of row death, my lord. And the apex court has given a golden principle, my lord, under what circumstances 304B can be made out, my lords. 10 golden principles are there. I want to take this honorable court, paragraph number 10 of the judgment, column number 1, my lords. Lords, I can be with my lords,
Yes.
with my all.
Yes.
Paragraph number 10, my lord.
Yes.
Column number 1, my lord. 10 golden principles. I have passed on that judgment law, my lord. That is
No, you are referring to impugned judgment or the judgment cited judgment?
Judge cited judgment.
Okay. Yes. First judgment, which one?
Good day.
Which one?
Yes.
Sunil Bajaj.
Sunil Bajaj, my lord.
Yes.
I with
Para 10.
Para 10, my lord. Paragraph 1, my lord.
Yes. Para 10.
Column number 1, my lord. With my lord's permission, I am placing. There is no evidence of a demand of dowry subjecting to summon to cruelty for in connection with dowry other than the general vague and inconsistent statement of interested motivated witnesses PW 4, 5 and 6 being parents and brother of the summon, my lord.
Yes.
In the present case, my lord, lords, you will find PW 3, PW 4, PW 11, PW 12 and PW 15 both are the relations of the deceased, my lord, and not a single independent persons have supported the prosecution case, my lord. Second contention before my lord is that para 2, my lord, not a single member, neighbor or a relative party either at Bhopal or at Saharanpur has come forward to speak about the subjecting summon to cruelty by the appellant in relation to demand of dowry, my lord. In the present case, your lordship find none of the persons, either the matrimonial house of the deceased or the immediate neighbors of the paternal house of the deceased have come forward to depose.
This judgment which you are citing is an appreciation of evidence of that case.
My lord,
What is the ratio of descending?
The ratio that
What is the ratio of this?
Even my lords has also own judgment. I am not brought
That's
that.
right. But see, if interested, see the demand of dowry is a family affairs. It is always not necessary that you would have independent witness.
My lord, this is that job.
So it is again, it's a matter of appreciation of evidence. This case, evidence is such. Then the court says that no, 304B is not made out because 498 is not made out.
Both are not made out, my lord.
So your proposition is the 498 is not made out. And then 304B is also not made out. That's what you want to say. But you have to see the evidence for this case.
Yes, my lord.
Separately.
I am just placing this judgment. Thereafter, I will
Yes.
Third contention is that telephonic information, my lord. No CDR and STR has been seized. Paragraph number 3, for which the court has taken adverse inference, my lord. Fourth is there, my lord. It has come in evidence of these witnesses of the appellant and the family members were well placed financially and parents of Suman big family and were not in comfortable financial. That is also applicable here, my lords. Financial active persons have financial well up, my lords. Fourth is that, my lord, there is no demand of dowry at the time of marriage 91. 2 children are there and some documents have been seized. In present case, no documents have been seized, my lord. It is alleged that 80,000 paid, my lord. Investigating officer has not seized any document to show that money was withdrawn from the bank and same was paid to the informant, my lord.
Yes.
That is paragraph 6, my lord. There is no evidence as to how Father Suman arranged money rupees 20,000 or 10,000, my lord. Thereafter, my lord, Paragraph 8, my lord. There are material contradictions, serious omissions in the statement of PW 4, 5, and 6 and can be seen from their evidence, my lord. My lord, senior has already placed the entire evidence, and my lord also has categorically considered view that entire evidence suffers from material contradiction. The story told by the PW 3, PW 4, and PW 11, PW 12, and PW 15, my lord. The scenario given by these witnesses, my lord, before the investigating agency, and a scenario given by the witnesses before this honorable court, my lord, material differs, my lord. That aspect has been proved by the PW 16 investigating officer, my lord, in a lengthy cross-examination. That this ratio has also applicable, my lord. That apart, my lord, another aspect lordship may kindly be taken into considerations. Marriage was solemnized in December 2002, my lord. That is December 2002, my lord. And deceased died, my lord, victim died, my lord, in 17/12/2004, my lord.
Yes.
During such a long interval, my lord, none of the family members, my lord, has reported such fact.
Marriage on? Date?
13th December 2002.
13 December 2002. And incident?
17/12/2004.
17/12/2000. For exact 2 years.
Yes, my lord.
Yes.
During such period, my lord, no information has been given before authority, my lord, with regard to the alleged torture at the earliest point of time, my lord. Yes. So in such backdrop, that judgment law, Sunil Balna's judgment speaks, my lords, that non-disclosure of the alleged incident at the earliest point of time, my lord, speaks the allegations appears to be highly concocted and unbelievable one, my lord. Taking into note the ratio of this judgment law, my lord, and this judgment law has got very squarely applied in the peculiar facts and circumstances of the case. I entirely concede with my law view, my lord. In criminal case, each case should fact and circumstance should differ, my lord. But the peculiarity is that this judgment law has got very squarely applied in the present case because no alleged it is found from the first information report. Soon after marriage, my lord, there is allegation of torture, my lord. But they did not prefer
Nothing there.
this aspect, my lord. Thereafter, my lord, second query was that whether the witnesses that suicidal tendency, my lord, suicidal tendency has been proved in by the defense in a preponderance and probability manner, my lord. To satisfy my lord's query, I want to refer the accused statement of Surya Narayan Acharya, my lord. That is the page book, page number 198. 198, my lord. That is page number 67 to 73, my lord. That is accused statement. Yes. And so also defense evidence has also examined. You will see first make a glance at page number 67 to 73.
Yes. Which question?
My blessing. Page number 73, exact page number, my lord.
73, yeah?
Yes, my lord.
Yes.
That is, my two pagings are there. One paging is 73, another is 57. But question number 39, my lord.
Question number 39.
Yes, my lord.
Last question. Yes. Read it.
With my lord's permission, I am placing, my lord.
Yes.
ବିନା ଯୌତୁକରେ ବିବାହ ହୋଇଛି ଆମେ ଗୋଟାଏ ସୁନ୍ଦର ଝିଅ ଖୋଜୁଥିଲୁ ସେତେବେଳେ ଜାଣିଲୁ ଝିଅ ସୁନ୍ଦର ଆମେ ବିବାହରେ ରାଜି ହେଲୁ ଝିଅର ବ୍ୟବହାର ଅତି ଭଲ ଆମେ ଆଶାନୁରୂପ ବୋହୂ ପାଇଲୁ ବନ୍ଧୁ ମଧ୍ୟ ଭଲ 29/6/2004 ଆମ ପୁଅ ମାର୍କେଟ ଗଲେ କିଛି ଜିନିଷ କିଣିବାକୁ ଆମେ କହିଲୁ ବାଟଘରେ ଶୁଅ ଶୋଇବା ସମୟରେ ରାତି ଅଧରେ ଠୋ ଠୋ ଶବ୍ଦ ଶୁଣିଲି ରାତି ଅଧରେ ପୁଅ ଡାକିଲି ମୁଁ ଆସି ଦେଖିଲି ବେଡ୍ ଉପରେ ଝୁଲୁଥିବା ହୋଇଛି ଲଗା ହେଇ ଝୁଲୁଛି। ମୁଁ କହିଲି ଝିଅ ନଟ୍ ଏଲିଜିବୁଲ ତୁ ଝିଅ ସେ ଆତ୍ମ କରିବାକୁ ଉଦ୍ୟମ ନେଇଛି। ଆମେ ତେଣୁ ତାକୁ ଦେଖାଇଛୁ।
Yes.
Thereafter, with my lord's permission, I want to invite my lord's attention, as very law is well settled. Defense evidence must stand on equal footing of prosecution witness, my lord. It is DW2, my lords.
Yes.
Page DW2.3, no? DW3, my lord. Page 184, my lord. DW is none else, my lord.
173.
184 बोधे
184.
184
Yes.
With my lord's permission, I am permitted to place my lord. I have been staying, not relevant. On 36/2004, the accused Surya Narayana had come to me for legal advice regarding the attempt to commit suicide of a deceased in the night 29/36/2004. Hearing the same as neighbor, I along with some others went to the house of accused Surya Narayana. I along with others, when asked the deceased, she replied that without her knowledge, she was about to commit suicide. When asked the deceased if accused persons did anything to her, she replied in a negative. Deceased also confessed that prior to the marriage, she had also attempted to commit suicide. Deceased replied that she could not know as to how she was attempting to commit suicide, my lord. In cross-examination, my lord, no suggestion has also been given that attempt to commit suicide made by the victim is a false one, my lord. No suggestion has been given, my lord. Only court has asked by invoking 165 of the Evidence Act to court, being an advocate, even though I came
I
to...
did not intimate it to the police.
Yes, sir. So, and a trial court has ignored such evidence. Why this witness did not disclose such fact before the police, my lord, on that score, my lord. With great respect, I want to refer that section 39 of CRPC. 39 of CRPC, my lord, envisages in which cases it is bounden duty on the part of a public to inform the police, my lord. And
but if you went to a lawyer, you should have got the right information, right advice.
Fortunately,
you chosen a right person to go, but what kind of advice he has given?
39 CRPC does not prescribe when a person aware with regard to the commission of a committing suicide, my lord, it is his bounden duty to inform the police.
That may be error of judgment in the part of the
yes, my lord,
not advising.
Yes, my lord.
That will not take away the veracity of the evidence. That's there. Yes.
Trial court has not considered that aspect, my lord. That the accused statement of Suryanarayan Acharya, my lord, and the evidence of a DW3, my lord. Similarly, my
she
lord,
had suicidal tendency,
my lord,
and she attempted earlier also.
Earlier, my lord. The accused
before marriage once, after between December 2002 to December 2004, within that is on June 1 attempt. June 2000. June 2004
yes, my lord.
Also one attempt.
The accused examined, accused Suryanarayan Acharya examined as a DW10, my lord.
DW?
10, my lord.
Yes, okay.
Under section 315 CRPC, my lord.
Yes.
And Lord C. McKinley grants the evidence of DW10, my lord. He has given a graphic picture, the various occasions how deceased made attempt to commit suicide, my lord. Very in very short,
Which part? The behavior of the disease was para 2.
Yes, ma'am.
No, para 3. Read para 3.
Yes, ma'am.
Read para 3.
On 29/6/2004 night, deceased attempt to commit suicide in her bedroom, and the call of my son Rabi. I, along with Rabi, forcibly broke open the door and rescued the deceased. When I asked the deceased as to why he was attempting to commit suicide, she revealed that she does not know how she was about to commit suicide. When I further asked if anybody told anything to her, she also replied,
negative.
it's a negative manner. Thereafter, all necessary care was taken. She was also revealed that while she was unmarried, she had also attempted to commit suicide, but she could not assign any reason. Thereafter, paragraph 4 manner thereafter. Thereafter, I consulted my son Rabbi about further course of action. I also consulted my neighbor Alam Babu, advocate manner, examined as a DW3 manner, who resides in the same line. On next morning, the said advocate, along with 2 or 3 others, came to my house and they asked the deceased about the reason, to which she resolved to reply satisfactory manner. When Advocate Ambabu asked the deceased if her husband or parents-in-law have told anything to her, she replied in a negative manner. The deceased also replied the same thing before the advocate Alam Babu DW3, what she had told before us. I have also discussed the said matter with one of the doctor, who told that this is the suicidal tendency. After the advice of the doctor, we are taking all precaution of the deceased manner.
Any prescription, anything is placed on?
No prescription has been, no prescription. And in cross-examination, my lord, you will see paragraph number 7, my lord. Nothing has been specifically asked, suggested with regard to that aspect, my lord. Another question.
Yes.
Thereafter, I want to invite my lord's attention the evidence of PW13, my lord. PW13 is a scientific officer.
Yes.
Scientific officer has also admitted
is
that is just my lord. Page 149.
Yes.
Scientific officer kahaku dekhiye. Sir, I, along with my photographer B.D. Bhoi and fingerprint sub-inspector Sarath Kumar Swai, arrived and participated in the spot visit, my lord, according to the evidence of the PW13, my lord. But
and which paragraph?
that is examination chief paragraph number 1.
What do you want to show? What do you want to show?
B.D. Bhoi and fingerprint sub-inspector Sarath Kumar Swai arrived and taken photographs, my lord. In the cross-examination, this witness admitted page number 152, my lord.
152.
Yes, my lord.
Yes.
Towards 5th line.
Yes.
The video cassette, still photographs are not available in the case record.
Where is that? I depose the same.
Page number 152, towards 6th line. The video cassette, still photographs are not available in the case
52,
record.
na? 52. Okay.
In our
I
paper.
brought down the also, the thermometers also. I cannot see. The video and cassettes. The photograph are not available on the record.
PW 13 mailer.
Yes.
This two material witnesses.
What do you want to show?
Mailer, because the examination of that photographers would have manifested the crime scene, any mark of violence or the position, they have not been examined deliberately, and photographs also not available in the records manner. Thereafter, and I want to invite my lord's attention, the evidence of the witnesses, my lord, suffers from material contradictions. So far that PW Informa 7 is concerned, and PW 3, 4, 7, and 11 and 12 concerned, my lord, they have implicated all the family members, my lord, in a vague and omnibus manner, my lord. I want to take this honorable court, my lord, the evidence of the PW 13, my lord, Arati Tripathi, my lord.
PW
13, my lord, who is none else, wife of the PW 7, my lord. PW 15, my lord. PW 15, my lord. PW 15, my lord. Arati Tripathi, page number 158.
Yes. Yes.
Yes, ma'am. With my lord's permission, I am placing. Paragraph number 2 of our examination chief.
Yes.
Whenever my deceased sister-in-law comes to my husband's house, she used to reveal about to torture on her by her father-in-law. Deceased Josnamoi died on 17/12/2005. On 12/12/2005, when the deceased came to her on 12/12/2005. When the deceased came to her parents' house, she revealed before me, on being asked that said torture by their father-in-law is still continuing. I was married 7 months. Thereafter marriage, this is the case matters. Other witnesses have implicated all the accused persons. These witnesses stated that deceased disclosed before me.
Might be she might have disclosed
Father-in-law, my lord. In view of such material contradiction, can my lord believe for a moment?
It can't be contradiction. They have given in minute details. She might not have given. It's not a contradiction. She has not taken the name of others. Doesn't mean that it's contradiction.
Had there been torture meted by others, my lord, in normal course that
we don't know whether this
could have disclosed that. Another aspect, Lord, she make us. Paragraph number. That aspect, my lord, implicating father-in-law, my lord, she has also not stated the same before the IO, my lord. That same has also been confronted to PW 15 in paragraph number 4, my lord. Thereafter, that contradictions have also been brought to the notice of PW 16, who has also denied she has also not disclosed such fact before her, my lord.
Yes.
Suppose, my lord, this witness has also admitted after delivery of the child, my lord, that all the festival, that is 21st day celebrations and other celebrations, have also been arranged by the accused person, and that has also manifested their bona fide conduct. I want to take this honorable court, paragraph 8, my lord, of this.
Yes.
Paragraph 8, my lord.
Hmm. What happened to that baby born out of the marriage?
Pardon me?
That the child born out of the marriage, he's surviving or she
She's surviving. She's surviving. She's surviving. That is also.
Stays with whom?
Stays with whom, my lord? I want to take this slide. My lord has also. That initially child was with the grandparents. Thereafter, the informant group, my lord, forcibly taken him, my lord. In this connection, I want to refer my lord's attention, DW.
Now, at present, where he is? With the maternal grandparents.
At present, my maternal. Subject to position, but that is maternal. You will also make a glance that evidence of her. That is DW7, my lord.
Yes.
Paragraph 2, my lord. I'm placing the evidence of DW2 in example.
DW2?
Yes, my lord. DW7, my lord.
Yes.
I have been working in DAV public school since 95. I know accused Rabindranath Acharya, who joined in the said school 2 months prior to my joining. To my knowledge, accused Rabi is a good man, and I have attended his marriage, also birthday ceremony of his son on 17/12/2004 at about 5 p.m. While I was in the house, I received information about the death of the deceased. On the same day, at about 5:30 p.m., I had gone to Capital Hospital, Bhubaneswar, and there I found accused persons were crying. I consoled them. I found some unpleasant situation in the hospital, and I came to know from accused Rabi that people of his father-in-law's family took away the baby from the custody of his mother. I have also seen such taking. Seeing the situation as colleague, I advised Rabi to go to PS on the same day at about 7 to 7:30 p.m. We went to Shahid Nagar PS, taking Rabi and his parents, and at the time one Vijay Ram Sahu, another colleague, was also with us. As per the instruction of police, we remained at Shahid Nagar PS throughout the night as the accused persons were crying. In order to console them, we remained there. On the next day morning, we took the accused person to Mahila PS, and thereafter we went to our house, my lord.
Have you initiated any proceeding for custody?
Yes, my lord. That initiation, there is no occasion on the part of the accused to initiate proceeding, my lord, because soon after the incident, they lost the affair and accused person was arrested, my lord. And in this connection, my lord, I want to invite my lord's attention the evidence of the PW16, my lord, investigating officer. While assessing such aspect, lord, you can glance that evidence of the PW16, my lord.
Yes.
The IO cross examination. I have submitted, my lords, before my lord, that evidence of defense witnesses who took the accused persons to Mahila police stations. In the IO has also admitted in its cross examination, paragraph 14, my lords.
14.
14, my lord. Page number 169. 169, my lord. I arrested the accused person at Mahila PS when the
PW?
PW, my lord, 16.
16. Yes.
With my lord's permission, I am pressing.
Hmm.
I arrested the accused persons at Mahila PS when they appeared before me voluntarily, my lord.
Yes.
So, in view of the admission of a PW 16, these accused persons are very much appearing at Mahila police station, and I have already placed the evidence of defense witnesses who have specifically stated we took the accused person to police station that derive some corroborations, my lord.
Yes.
Thereafter, I want to invite my lord's attention the evidence of a PW 12, my lord.
Yes. Yes.
Nirmala Tripathi, my lord. Page number 143, my lord. 143, 143.
143. Yes.
This witness has admitted in his cross examination paragraph number 3, my lord. Paragraph number 3, my lord.
Yes.
Chaturbhaja Rauturai, my lord, the matchmaker mediator, my lord, is working as a PA attached to Nirmana South office. I came to know Chaturbhaja Rauturai 1 year prior to the marriage of deceased daughter. For the first time, I came to know about to demand from Chaturbhaja Rauturai mediator. Chaturbhaja Rauturai and myself are government servant. We know giving and taking of a dowry is an offense. I have not told anybody, secretariat, including my officer, regarding such demand. And Chaturbhaja Rauturai, my lords, has also not been examined in the present case, my lord. He is a very material witness, as my learned senior has already submitted that Chaturbhaja Rauturai, my lord, in his presence, my lord, entire largest transaction made, he has not been examined.
Yes.
Evidence of this witness, my lord, entire evidence suffers from material contradiction, my lord. That has been confronted in his paragraph number, my lord. That is paragraph number 9, my lord.
Yes.
Paragraph number 9. That is, my lord. Paragraph number 5, my lords. And in cross-examination, my lord, defense has also suggested that suicidal tendency to this witness. Of course, this witness has disowned the same, but defense has also suggested, this witness has replied, it is not a fact. Daughter had suicidal tendency and she was attempting to commit suicide time and again, and that on date of occurrence, accused Sujay Narayana, Ravi Narayana were absent in the house. They had gone to their respective house. The suggestion has also been given this witness, my lord. Lordship find from the cross-examination paragraph number 5 towards end, my lord.
Yes, I have seen.
Yes, ma'am. Thereafter, I want to invite my lord's attention evidence of a PW 11, my lord.
11.
Yes, ma'am.
Yes.
Is the relation of the brother-in-law.
Yes.
Brother-in-law.
This has already been pointed out.
Yes, my lord. Only my lord, senior has also submitted paragraph number 4, my lord. She has admitted at about 10 to 15 6 days prior to date of marriage, on the date of negotiation, I came to know accused persons, but prior to that, I am not acquainted. Relevant portion is at the time of negotiations. Apart from my brother-in-law Nihar Ranjan Tripathi, Manoranjana Tripathi, Radhakanta Das, mediator Chaturabhuja Raut, Dasaratha Mahanti, and others were present, my lord. That Chaturabhuja and Dasaratha Mahanti, they have not been examined, my lord.
Yes, I think Mr. Mahapatra has shown me also.
Explain, my lord.
Any substantial thing if you want to.
Any substantial, my lord, I want to invite my lord's attention that PW 15, my lord, has also stated during her marriage ceremony, the accused persons visited and also presented a golden bangle to her, my lord. Suppose there had been a strained relation, my lord, can my lord conceive her a moment the accused person visited and presented a golden bangle for that purpose, my lord? That appears to be highly doubtful, my lord.
Yes.
And so far that other evidence is concerned, my lord, that first information report, lordship would find from the first information report making against the affair, my lord. In affair, PW state 7 has specifically stated 1,50,000 has already been paid on the day of marriage, my lord. But subsequently, other witnesses have stated demand was 1,50,000. We have
60,000 and all have changed.
That is also highly doubtful, my lord. Another aspect, my lord, very scribing of affair by the PW7, my lord, is also very doubtful, my lord. Because PW7 has also admitted, I have not scribed the affair, same has been scribed by the PW11, my lord. But PW11, my lord. And PW11, Lalit has nowhere stated, I have also scribed the affair, my lord. So very lodging of a the narration of affair is appears to be prosecution is in deep crisis.
Niharanjan is exhibit.
Niharanjan PW7, man. PW7, according to the evidence of PW7, same has been scribed by the PW11, Lalit, my lord. Lalit has nowhere stated, same has been scribed by him, man. In view of such material contradictions appearing in the evidence of witnesses, all witnesses are interested and related partisans, and the material witnesses Chaturabhuja Dasaratha have not been examined, my lords. And no periodic information of a doubt torture has been given before any authority, my lord. That there is nothing in the record to show that deceased was subjected to cruelty and harassment soon before her death, my lord. Conduct of, your lordship can make a glance. All the independent witnesses have specifically stated, including defense witnesses have specifically stated, on the alleged day of incident, the accused Suchanarana Acharya, accused Rabinarjana Acharya, both were in their working place, my lord. After getting information, they rushed to their house, my lord, immediately shifted the victim to the hospital. Thereafter, accused appellant Rabi intimated such information to the informant's family, my lord. And such fact has also been manifested their bona fide conduct, my lords. Even IO has also admitted, my lord, they voluntarily appeared, my lord. Taking note of all the fact and circumstance of the case, my lords. And so far that my lords has got own judgment law, I will refer it, my lord. And that is a very recent judgment of our own High Court, my lord, Justice Coordinate Bench observed. Prosecution must be very consistent with regard to exact date of a torture, manner of a torture, and on that score case, the coordinate bench has also acquitted the accused person under 4B. My humble submission before my lord is that there is absolutely no evidence record. There is a close proximity between the alleged torture based on dowry demand and cause of death, my lord. And the dowry demand story appears to be very inconsistent in nature. PW7 stated we have given 1,50,000. She has also mentioned the same in the first information report. And the investigating official, I want to take my lord's attention that last not what placed, but the investigating official what make that investigating officer has also fairly admitted in his cross-examination the inconsistency of a prosecution with regard to that alleged amount of dowry, my lord. PW 16, my lord. Cross-examination, my lord. That is paragraph 18, my lord.
Yes.
What's the 15th line, my lord? Paragraph number 18, 18 paragraph, 15th line, 15 line. With my lord's permission, I'm placing. The fact I have mentioned under a brief history of a charge sheet that a demand of 1 lakh was given has not been stated by anybody before me. The witness volunteers, complainant Nihar Ranjan Tripathi has stated before her there was a demand of 1 lakh by the accused person for the purchase of land, Bokhariputu. The complainant, paragraph 19, the complainant Nihar Ranjan Tripathi himself has scribed the FIR, the correction was made, my lord. According to the FIR, lord should find the entire 1,50,000, my lord, has already been paid, my lord. With my lord's permission, I am placing that FIR few lines, my lord. ପରିବାର ଦାବି ମୁତାବକ ଯୌତୁକ ବାବଦକୁ 1,50,000 ଟଙ୍କା, ସୁନା ହାର, ସୁନା କାଚ, ସୁନା ମୁଦି, ସୁନା ଚେନ୍, ସୁନା କଂସା ବାସନ, ପିତ୍ତଳ ପ୍ରତ୍ୟେକ ଅନ୍ୟାନ୍ୟ ଆସବାସ ଦେଇଥିଲୁ ହଜୁର. Once that has already been complied, so further demand that 80,000 paid and for which torture meted out, that appears to be very afterthought and highly unbelievable, man.
Yes.
I think it's all right now.
Yes, ma'am.
Mr. Pandit.
That apart, my lord, also they have been the old persons, father-in-law, mother-in-law, and old person, they have already twilight evening stage of their life. And husband, Rabindranath Acharya, is the only source of their survival. There is no other alternative. That aspect, they have also been felt the rigor of the law by roaming from pillar to post for a decade, my lord. And in view of such a peculiar fact and circumstance, appeal to my lord,
Rabindranath
is the only son, my lord.
is now he must be about 60.
Yes, my lord. And he's 60. 60 and he has already married. Because after death of first wife married and blessed with a child, my lord. And these all people are, Rabindranath is the only source of their survival, my lords. These are the propositions that my lord senior has filed a written note argument, and I have also checked. My lord has also recently delivered a judgment in the case of 304B and 304B 313. It will forget and we will refer this in our
Note.
Yes,
Note of submission.
Yes,
Yes.
My lord, I am entering my appearance.
my
for
friend is there also.
one of the, my lord, that
You are
That
appealing for?
or one of the
Savitri ma'am, for lady appellant ma'am. Bhakilat Nama has earlier filed ma'am. He is along with us.
Then you appeared for
Savitri Hajur. Appellant number 2, ma'am. Sujana number is appellant number 1.
you are appearing for
Myself and my senior both are appearing for
Mr. Raghuda.
Suryanarayan and Ravi Narayan.
Are you
I
want to add anything?
want to supplement my lord something. My lord, can you see page number 62 of the FIR, my lord, last paragraph. ଏହା ପରେ ମୁଁ ଘରକୁ ଫେରି ଆସି ବାପା ଓ ମାଙ୍କୁ ସବୁ କହିବାରୁ ସେମାନେ କହିଲେ ନୂଆ ବନ୍ଧୁ ଆମ ଝିଅ ଦେଇଛେ ତେଣୁ ମୁଣ୍ଡ ନୁଆଇ ରହିବା। କାଲି
କାଳକ୍ରମେ ପରିସ୍ଥିତି ଭଲ ହେଇଯିବ ମାନେ ଭେରି ଇମ୍ପୋର୍ଟାଣ୍ଟ ଆମ୍ଭେ ମାନେ ତାଙ୍କ ତୁଳନାରେ ଗରିବ ଲୋକ ଭଗବାନଙ୍କ ଆସ୍ଥା my lord. But this is very important. There are certain judgment of the apex court my lord. If the parents of the deceased are in a poor condition my lord, the question of demanding further dowry judgment arise my lord. I will cite that judgment my lord. One judgment there my lord, apex court my lord. Sunil Bajaj, another my lord. Your lordship relying that judgment recently in April part my lord. Your lordship delivered judgment relying my lord 2010 OCR page 768 I will cite my lord. Relying that acquitted one person on 304B my lord. Recently on April part your lordship my lord. And here is a question my lord. If the accused persons old to do family my lord belongs to old to do family my lord, their status is very my lord, the well my lord. The question of a subsequent my lord demand of dowry does not arise my lord. And here is a case my lord. The informant who is the P7, he categorically stated that there was a 1,50,000 and some household articles they have already given my lord. The question of a further judgment arise, and some of the witnesses my lord, those are relative of the deceased my lord, they have stated that 80,000 are up to they have given 80,000 my lord. For the rest amount they have demanded the 100 motorcycle matter. The question my lord that is not arise since the accused persons my lord old to more than my rich persons the father of the deceased my lord. And second question my lord, now the case my lord, even if the statement of the P7 taken to consideration my lord, his evidence is full of contradiction my lord. All the contradictions put to the I of P16 my lord. I have categorically stated my lord, I have pointed out if lordship, that is my lord the P16 my lord, the IO. 16 my lord, page starting by 162 my lord. Paragraph
20.
21 my lord, 20. It is a fact that P4 did not state that before me.
162. May kindly see
175.
Page 174 starts from para 20. Yes. It is a fact.
It is a fact that P4 did not state before me that P4 another my lord, the brother of the deceased my lord. His elder brother, mother and other brother-in-law used to go to the house of the accused person to request them not to torture this my lord. This subsequent torture, even if my lord, why I am mentioning that my lord, the brother stated, P7 stated while he was at the house of the accused persons, the deceased told them that they are torturing and the in-laws demanding more dowry and also the inferior quality of dowry materials they are they have started torturing me. Even if my lord, to that respect my lord, there is no such my lord the FR laws prior to when the deceased alive my lord.
That Mr. Das is saying.
By the time no FR laws my lord, there is no meeting, punch meetings there my lord. That department taken into consideration my lord on the apex court and other courts my lord. My lord, that is there my lord. Again say that you don't stated before me that the elder brother of mother used to request the accused persons, that is not the fact my lord. So my lord, P4 categorically stated that there is absolutely no torture and this is not told before them my lord. Paragraph 21. It is a fact that I oppose it. It is a fact that P7 Nihar Ranjan Tripathi did not specifically state before me that they paid on such article down towards demand and other accused persons source demanded Hero Honda Splendor cycle that the day after the marriage when he had gone to the house of the accused persons misbehaved him, but there is a very important matter, drove him out of the giving push by his neck and by body and neck, and that after such misbehavior he did not go to the house of the accused persons. 15 days about thereafter, this is my lord, all my lord, the evidences of the my lord P7 is full of contradiction my lord. That is subsequent development my lord. That is not in the 161 and so far the FIR my lord. That is my lord subsequent development. But the entire my lord paragraph 21 my lord, that may be taken into consideration my lord. Also my lord, same paragraph my lord. it is a fact that, page 177, second paragraph.
Yes.
It is a fact that PW7 did not further stated before me that I learned from the persons near to the house of the accused persons after his arrival that the precedent night there was a lot of noise and quarrel in the house of the accused persons, and in the morning there was a complete silence, and about 3 p.m. they learned that his sister had been taken to the hospital and that the accused person committed murder of the deceased. But that is not he has stated before and subsequently stated before the IO, my lord, in his evidence in chief, my lord. That is also contradiction, my lord. Entire, my lord. And towards that, my lord, it is a fact that we did not stated before that whenever he visited the house of the accused persons, he marked the sign of assault on the body of the deceased, my lord. Though he has stated that whenever he visited the house of the deceased, he found some injury mark.
176 last 4 line reading.
My lord. 170.
Witness volunteer 176.
My lord.
Last 4
7, that the accused persons are demanding cash motorcycle, telling which the accused persons would kill her.
The witness volunteer.
My lord, volunteer. But in fact, he has not stated in his 161 statement and also the FIR, my lord.
Where this is the incident for 12/12/2025.
25.
Is close proximity to the incident which has happened on 17.
My lord.
That's what.
That is not there in his 161 statement, my lord. For that time, my lord, that is contradiction, my lord.
Yes.
For that is, there is, and my lord, it is a case based on it is a better case so far, my lord, for argument, sake of argument, as because none of the, my lord, independent witness supported the prosecution story, my lord.
That's right.
And only because basing on the statement of the prosecution witnesses, my lord, the court will convict the accused persons, my lord. And the entire evidence of all the witnesses are contradicted to each other, my lord. Some persons stated, and my lord, there is no, my lord, such evidence that soon before or that she is subject to cruelty.
And in what point the contradictions are there? See, insofar as the family members are concerned, 3, 4, 7, 11, 12, and 15. You prepare a chart and give me.
One of the brother of the deceased, he stated that after death of the deceased, the husband of the deceased went to the house of the landlord of the.
Prepare a chart. Prepare a tabular form. And give me who contracted where. That will be easier instead of
already filed a written note argument.
Yes. There you prepare a tabular form. And PW 3, 4, 7, 11, 12, and 15. What are the contradictions? It's just tabular form you give. That will be easier to.
Comparatively, if it will be placed, your own can
easily one can.
Yes,
I can refer to pages.
Another aspect, my lord, that learned trial court has given much emphasis to the 161 statement of the witness.
The 161.
Your lordship make the mass. As the witnesses were stated in their respective 161 statement, even if he has not stated the same before the court, but I do not want to disbelieve them. On that spot, trial court has convicted. Lordship may.
Yes, Mr. Panagiri.
Let them complete.
Complete.
So far as initial demand of dowry is concerned, I admit some contradictions are there, but the fact remains that soon before her death, she was subjected to cruelty or harassment.
That is on that evidence of 12/12.
Yes.
Yes.
That evidence is there. So this is a case of dowry death. Family members are the best persons to say this.
Right.
And in case of natural witnesses, some inconsistencies will be there. Nobody will state like a parrot.
Yes.
And so far as non-examination of witnesses are concerned, that
That is
Dashrath and
not
Shatrughan, they are not even charge-sheeted witnesses.
So many witnesses have been examined.
Yes, but they are not charge-sheeted witnesses. Had they been charge-sheeted witnesses and prosecution did not examine them, an adverse inference will be drawn that prosecution deliberately suppressed some material facts. But in this case, they are not charge-sheeted witnesses. So evidence is there, and she died within 2 years of her marriage. And the death is admittedly unnatural. She committed suicide.
Let us see the postmortem.
Yes, PW doctor is
13.
14.
Doctor has stated that death is suicidal to court.
Is 154.
Paragraph 14 can clear. Same paragraph 14, page 157. Report possession. Usually we do not write the PL. Report in
Suicidal death.
death of asphyxia by hanging, that is the suicidal death. Clear code man doubt hele possession.
That's a suicidal death.
Suicide.
आप मैं को रेलेवेंस है वो के लिए जोड़ में आउट ऑफ ऑर्डर यूज्ड
The ligature mark was also the ligature mark was also oblique. In case of strangulation or other thing, that will not be oblique. There will be multiple ligature marks.
So then, under the aid of that presumption, you are bringing 304.
Yes.
P.
So it's a case under section 304B, not a case of 302.
Yes.
And so far as delay in dispatch of FIR is concerned, they have taken a plea. No questions were put to the IO regarding delay in dispatch of FIR to the magistrate.
Evidence is true.
I'll file a written note.
And what about the suicidal tendency thing?
Have they reported? They are saying that so far as demand of dowry is concerned, no, it was not intimated to police at the earliest point of time. If the deceased had attempted to commit suicide,
And
had
they
they
consulted
intimated the
the
police
problem is they consulted a lawyer. And thereafter also they didn't go. That's the problem. Instead of a lawyer, if they would have consulted someone else, one can understand.
No, why they
Consulted a lawyer.
didn't? They did not intimate as family members. They should have intimated the police that.
And prior to marriage once, and after marriage in June, one attempt was made.
They should have intimated the police that she is attempting to commit
Yes,
suicide.
my lord. The accused persons have no grievance against this is my lord. Why should they go to file a law FIR, my lord? Since
Obviously, why should they have a grievance?
They have no grievance at all. Or rather, they stated that the vote of
And the grievance is otherwise.
And Podosi man bhi kehi kahuna.
Grievance is otherwise.
After before death kehi kahuna to be after death has
Then you file a written
Right.
argument.
And I must confess, my lord, what I gathered from our senior while I was junior man going to trial court. All the things I learned from my senior.
That's the learning process.
I under training, my lord.
And this paragraph, Mr. Das, the judgment which you are citing,
Sir,
you please write down the paragraph.
ये paragraph.
Paragraph.
Let me have it.
Give it, take note.
May I say one thing, my lord?
वो दे दिया तो
What's the period undergone?
2 months.
18/12/2004 arrested, and 30 January you were got bail. January 2007 again arrested, and February you got.
Senior man has to.
Yes, sir.
May I say one thing?
Yes, sir.
We are here, all of us. Our duty to see that things shall be churned and cream will come out. This is our motto. Whatever the result of the case, we are not concerned. Here is the case. After filing the note of argument by my friend on behalf of the State Council, I simply pray that I will just analyze his note of argument, our note of argument, and brief the things for better appreciation of the entire case.
Then
That
you
was
want
better.
that it should be once again heard after he filed the note.
Yes.
You want a hearing.
Yeah. Just to give the synopsis of the entire thing.
Heard Mr. A.C. Mohapatra, Mr. Devasnam Das, and Mr. Vijay Ravada. separately for the accused person, and Mr. Pangre for the state, for the state. Hearing concluded. Hearing concluded, judgment. Hearing concluded, sir. The counsels for the parties to file the written notice for submission and a comparative charge. Comparative charge. Mr. Mahapatra, senior counsel submits that after Mr. Pangre, the state counsel files a written note of submission, one more opportunity may be granted to the revert the same, revert of the reply to the reply the written submission by the state counsel. Lease the matter. When do you want? How much time will it take?
I will file by Friday.
Friday. Then
on Tuesday or Thursday as convenient to my learned senior. I will serve.
Then the only thing what Friday to Friday. And either 19 or let it be there in the 19 AGT there. Weekly. It will be there in the weekly list 19. Okay. Okay.
Open number of them.
44. Not there. It's my, yes. Yes.
Item 44.
Yes. The total, I think I have received the evidence of 6 witnesses. I think this is total evidence is 6. So far yes. So far the trial court judgment is concerned. 6 witnesses has been examined on behalf of the prosecution.
I was not examined.
And I was not examined. Even though the victim has stated that I have been examined by the medically, but no doctor has been examined. Nothing has been mentioned so far the injury report is concerned.
You convicted for
376 511. Question is the fact is that it is alleged that the accused came and asked
whether it is 376 or 511.
No, 376 511 conviction.
Okay, conviction.
And acquittal from section 3 SST Act.
Okay.
Trial court disbelieved the evidence. Accordingly, he was acquitted from section 3 of the SST Act.
Sentence?
2 years.
Let us see the prosecutrix first.
Only basing on the evidence of
Prosecutrix.
victim, the trial court convicted the accused.
Who is the
Victim is the
PW1?
PW1. Page 17.
When doctor is not examined.
No doctor examined, no
And
IO examined.
Exhibit?
No.
Medical report exhibited?
No, kitchen. Kitchen I got a caste certificate को exhibit करते ले सेटअप तो disbelieve कराई.
What is the evidence? Khageshwar examined?
Khageshwar examined. He contradicts. Khageshwar is 2.
Okay, sir. He is the scribe of the what?
Scribe order. He has stated, I had not seen the accused entering or coming out of the house of the victim. I had not gone with her to the PS. It is not a fact that Pani told me that accused tried to snatch away with the hen. It is a fact that I do not know anything about. I am deposing falsely. But the other witness have stated that ये जो कुकुड़ा को नबाको कुकुड़ा नबा पाई झगड़ा ହେଇଥିଲା ତେଣୁ କୁକୁଡ଼ାକୁ ଟାଣିକି ନେଲା ବେଳେ ସେ ପଡ଼ିକି ଖଣ୍ଡିଆ ହେଇଛି ଏ କଥା ମଧ୍ୟ ଅନ୍ୟ ୱିଟନେସ୍ କହୁଛନ୍ତି ସେ କହୁଛି ଇଏ because I had not seen accused at the spot.
PW2.
Yes, PW4. You also may kindly see page 20. I had not seen the accused at the spot. You also got it?
Yes.
Page 20. Cross examination. I had not seen accused at the spot. It is not a fact that Pani had not told me that there was a quarrel for sale of hen. And it is not a fact that I am deposing falsely. କହୁଛି କୁକୁଡ଼ା ପାଇଁ ଝଗଡ଼ା ଏଇଟା ଗୋଟେ କରିଛନ୍ତି ଆଉ ଯଦି ବି ଇଞ୍ଜୁରି ହେଇଛି ଏଇଟା କୋଉ ଡକ୍ଟର ବି ପ୍ରୁଭ୍ କରିବ କି ସେଟା କେମିତି ପ୍ରୁଭ୍ କେମିତି ହବ ସେ କେମିତି
report reveals injury is there on face, but how these documents are marked as exhibits?
କିଛି ତ କିଛି ଗୋଟେ କରିନାହାନ୍ତି
Nothing is there. This injury report and caste certificate he has marked as an exhibit.
Exhibit
Exhibit 1 and 3.
Caste certificate exhibit 2. 1 minute exhibit.
At whose instance it was marked?
Injury report is there.
Injury report is
ଦେଇଛନ୍ତି
there.
କିନ୍ତୁ କିଛି ନାହିଁ ତାଦେହରେ କିଏ ତାକୁ ମାର୍କ କଲା କେମିତି ମାର୍କ ହେଲା
Confusion, Louis, right zygomatic.
କେମିତି ଆସିଲା ଆଦ୍ୟକୁ ସେଟା ଟ୍ରାଏଲ କୋର୍ଟ ବି ଜଜମେଣ୍ଟରେ ବି କୋଉଠି ଜାଗାରେ ବି ଗୋଟେ ଲେଖା ହେଇନି ଇଞ୍ଜୁରି ଉପରେ କିଏ ଆସିଲା ଡକ୍ଟର କେମିତି କହିଲା କି କୋଉ ରିପୋର୍ଟ ଆସିଲା କି ହଁ ଇଞ୍ଜୁରି ପାଇଛୁ
Examine in presence of Manorama Deuri, the lady attendant. Manorama Deuri examine?
No. आयो କାହିଁକି ଏକ୍ଜାମ ହେଇନି ନା ଆମେ ଜାଣିନୁ ଆयो କୁଆଡେ ଗଲା ଆମେ where it is not known. So far doctor is concerned, totally silent. The judgment is also totally silent. Solely basing on the evidence of the victims, he has been condemned.
IO is not examined, so therefore the medical record also could not be exhibited. What to do?
କିଏ ଏକ୍ଜିବିଟ୍ କଲା ତାକୁ ଯଦି ଆଇଓ ଆସିଲା ନାହିଁ ତାହେଲେ ମେଡିକାଲ ରିପୋର୍ଟ ଏକ୍ଜିବିଟ୍ କିଏ କଲା ଡକ୍ଟର ତ ଆସିନି
Exhibit is not exhibited.
ହଁ ସେ ଗୋଟେ ଲେଖିଛନ୍ତି
But exhibit could like
ଇଞ୍ଜୁରି ରିପୋର୍ଟ ଏକ୍ଜିବିଟେଡ୍ ଆଜ୍ ଏକ୍ଜିବିଟ୍
Exhibit
1
mark
ଏକ୍ଜିବିଟ୍
କାହା ଥ୍ରୁ exhibit ହେଇଛି କିଛି ନାହିଁ.
list of exhibits.
ଲେଖିଦେଇଛିନି
But who has done it? How this document is brought on record?
Exactly, that is the whole point.
Marked as exhibit 1. caste certificate. Injury report रे किसी लिखा है.
This is exhibit 1, no? 2.
कोड कर इंजुरी रिपोर्ट
Injury report रे किसी exhibit लिखा है.
Exhibit in the kind.
किंतु तार
But there
कॉलम
is a
रे लिखि
signature
छै एग्जीबिट
Exhibit 3.
हां
This is exhibit 3, yeah? Exhibit 3 लिखा है. Let us see the witness through whom it is brought into the
को विटनेस किछि कोन ना ए इंजुरी रिपोर्ट आसला केमति कोन कला किछि कोन judgment paragraph 10 you will also make understand.
exhibit mark केम देला.
सेटा किछि नै तार माने किछि नमूना नै जे हम एक्सेप्टेंट करबा कि एमती हाउ इट हैज बीन मार्क्ड नो सच ट्रेंड हैज आल्सो बीन examined in
Judgment रे खाली लिखि देछन exhibit 1 caste certificate. Exhibit 2 FIR, exhibit 3 injury.
Sir, exhibit कॉले केम दी.
Nothing is there. None of the witnesses are.
Para
Judgment's last page.
judgment or last page
Soft copy LCR page 50.
yes
yes.
Exhibit 1 is marked by at the instance of PW1 caste certificate.
caste certificate em je mu
It is further continued that as per rule 7 of the SC, offense shown so should
that has been disbelieved.
Evidence does not indicate that allegations from so.
Exhibit 2 at the instance of PW2. At the injury report, none of the
Paragraph deals with the limit. No, mine. There is nothing in this one. Okay, this one. Okay.
yeah